the magistrate, door lock won't open from the bench.
Just,
Maybe the keys.
wait, just, yeah, keep holding on to it.
No, I pressed it.
It won't
still
open
says-
from the
it still
bench.
goes red.
And it,
It's supposed to be red.
Okay.
Red is on. Red is open.
4155.
Oh, okay. My
Okay.
mistake. I thought it turned off.
I don't think it's
the
open.
opposite here.
She did it already, it's not open.
Now it's locked.
Yeah,
Okay, I pressed it,
I
yeah.
called someone.
Okay. It's all on, yeah.
If you, red means,
It's pressed in and it's red, but it's
Yeah.
still not opening?
Yeah,
No.
someone's coming, cause it's probably has to do with keys.
no. Here, it's the opposite, they rewired here, it's really messed up.
Oh, I pressed it in.
When you have a chance, you can read the records on the DV, but just leave it out, because I'm
But
gonna
it's the opposite. The
contact
wiring
someone in
rewired.
FLPD to see if I can get a copy of that report.
Okay.
So every time they would lock, it would lock us. Every time they would open, it would open, so
Maybe it goes back to that, who knows?
I have no idea. Is everything okay?
Yes, it is, thank you.
Is this water old or medium now?
It's probably old, though.
Oh, okay.
Yeah.
Good morning. Yeah. Nice for you. You must be exhausted.
Yeah. It's good money, bad anywhere else.
Did you talk to Jill? Wonder if she's coming. Let me see if I can. I don't know about the girls' thing.
I'm back. Why do you say that? No.
Okay, so, hey Dave, it's Eric. Hey, got a case where it's a Grand Theft Auto. The PC's not that great, but the officer makes mention that the defendant was the listed suspect from the original report. Is there any way you may be able to assist me in getting the original report? Maybe it's in records? Well, the problem is that it doesn't list the original report number. It does list the victim's name. So maybe that would be able to, they could locate it for her, because since she would have filed the original report since her car was stolen. Karen Claudia Davis. Yes.
Yeah, we're doing it.
Yes, and I have her address. I don't know if that'll help. Like I said, it's not a great report. I do have the car information. Okay, perfect. 34-1709-149023. Witnesse's name is Jamal, Jamal, last name Patterson. And if you could just call me back at 7447. I'm hoping that base I can combine this report with the original preliminary, and if not, then I'll call that Stroud. All right, thanks, sir.
Hello? Hello? Yes. Who's this? You're here this morning, Ricky.
I'm done with that.
Okay.
Are you gonna be able to make that bond? It sounds like you might have some issues. Wanna know where you are? What's your mom's name? What's mom's number?
Or prior's gonna matter. If they committed a no law offense and it's a violation of probation with no bond.
Is it? Probably not. But let's see what the new offense is. No, for possession of cocaine.
No.
Because I'm like, even if there wasn't a VOP and he had a record, we probably
Yeah.
just ask the bond to be kept at 1,000 anyway.
Okay.
Okay, just put the phone down, don't hang it up, and then we'll talk to the next person, okay? Okay, you're welcome. Ricky, I've got to talk to the people that are, okay, so don't hang the phone up. Just put it down. I just want to use it to the public defender's office. Gotta get smart. I'm doing smart. See what I got? Okay, I got a couple things on it for the judge this morning. One is a possession of some type of drugs. On a matter of $1,000. We've got some violation of probation charges that is being held no bond on, and there's nothing that the judge can do about those this morning. You have a court date September 26th, which is in 4 days, at 8:30 in the morning, okay? Any physical health issues that have to be aware of? Any mental health issues that are involved? Okay, so you're fine?
I remember last time I had the issue with the petty thefts because they didn't have, like the prior offense, whatever. I think there's 2 of them that I'm gonna have an issue with today.
Well, we'll see. Sometimes the court will let you get away with that for judicial notice.
Yeah, cause
Oh, this one I wouldn't want. This kind of stuff, when they charge them as a misdemeanor, don't worry about it because let's see
Okay.
how much it is.
but I have one that's a 3rd-degree felony, but he doesn't
It's like
actually.
$152 worth of stuff.
Right.
That would be a
So it's
first
gonna
degree-
be
even
it
if
anyway.
Even if it was his first, it would be a first degree misdemeanor, $100
Right.
fine.
Okay, I
Don't
just
worry
didn't.
about that.
I wanted
That's
to make
not-
sure. Okay.
that's
Yeah,
not-
'cause I know
they're
when
not-
I-
They're not gonna object to that. I
Yeah,
don't think.
because when I see it, it's still 1st-degree misdemeanor anyway because of the amount. Yeah, I had one though that was a.
Technically, go back to Stephen Ross real quick, it's a couple cases back. Technically, that's a PDL. usually don't ask for no bonds on burglary.
He
damage
has,
over
he has a lot of pending ones right now.
Exactly. So that's why
Yeah.
I wouldn't worry about it.
Okay. So you think
What
it's
I'll
gonna be
do-
no bond?
No, 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 no.
Or,
Because
oh, it's no
sidebar,
bond anyway. Oh, I see what you're saying.
No, 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 no. It's a
Music?
PBL. But normally, with burglary with damage over $1,000
Oh,
is a
from
PBL.
outside? Oh, okay.
Normally, I don't
That's
ask
what
for
it
no
was.
bond on those, because it's just,
Okay,
unless it's really, really, really egregious facts.
right,
Now,
and
so-
it's not, it's just a
And considering
business.
it's 40, what I'll do, and stuff like that is, what I'll do, let's say it was just a regular burglary.
Mm-hmm.
What's his last name?
Which one?
Trying to find him. This guy's been in custody since February. So what I'll do, what I normally do on those is, I'll just look and see what the other charge is.
Mm-hmm.
Yeah. He's, his other
Yeah.
burglars damage over 1,000, he's been 15,000, so yeah, just ask for that on this too, and that's, we were 15, so perfect.
15?
Yeah.
Okay.
And I'll look at, that's what his other ones have been set at. Here are the DVs you can put to the side for now.
Which ones are these?
Those are DVs.
Oh.
Just put those to the side for now.
Okay.
Is the theft, it's something you've already gone through? I'll
Yeah,
find it.
it's a third,
Yeah.
third offense, so it's a felony.
Earl Mitchell?
Yes, is that? It's, yeah, I think I only had one.
It says NCIC revealed 2 prior larcenies, so maybe you only had one in Broward. Maybe you only had one in Broward. Also, it doesn't, they don't have to be thefts.
I don't know if this one's.
Grand Theft Auto, see, I'm pretty sure it can be any kind of theft related.
I thought it had to, I don't,
I'm pretty sure it could be any theft related.
let me make sure this is the right piece. Oh, yeah, maybe it's not him then.
But they
I
may
might-
have someone else, because he definitely has 2.
Yeah, because I wouldn't have,
Okay, okay, then maybe it's someone else.
yeah,
Are you putting them on top or in the bottom of the?
on top of them. Yeah, because there was one where I was looking and
Yeah,
it's definitely a blackmail.
it doesn't get fixed. We usually profit.
I didn't see any.
Maybe I'm losing my mind. That's probably,
Happens.
yeah. Because I was looking at it, I'm like, oh, well, there's a pending grand theft, or, but I'm like, but it's not adjudication. I know that for it to be, you know, to count, it has to be an adjudication.
Good.
Okay.
See here, look, a person who commits petty theft and who has been previously convicted 2 or more times of any theft.
Right.
So it could be
Yeah.
grand theft. it
Oh,
could be
no.
grand theft
Oh, no,
auto,
I knew
'cause
that.
He's got a million.
Yeah, yeah, yeah.
Okay.
See, that's why I totally wouldn't have, I'm
Matter of
thinking,
fact,
I
matter of fact,
lost
it
my
doesn't
mind.
even have to be theft, it could be robbery. 'Cause
Okay,
in
any
order to
kind
commit
of
a
theft,
robbery, you're taking
you're
property
taking,
of another.
okay, okay. Yeah, because when I'm filing those cases, you know, I know that when I look at priors, like of petty thefts and stuff, I, you know, I consider grand theft autos also.
Of course, yeah, any
Yeah,
theft.
okay, robbery too, yeah, that, I've never had
I
that.
mean, I think you can make the argument in good faith at least
Yeah.
that you can't commit a robbery without it taking a property.
Right, right, absolutely,
Which is all that's required to commit a theft. It's basically a theft with force. That's,
yeah.
just just make sure it wasn't an attempted robbery, because it might show in our system robbery, but they might have fled that to attempt.
Yeah.
Since there is no attempted theft, but there is an attempted robbery.
Oh, you know what my issue with that one might have been? Maybe because they didn't put the priors in, that doesn't matter. Because last time he argued,
And if they
or
argue
doesn't
that,
say it in
then
there.
what I would say is, Judge, I can give you case numbers first. I'd ask the court can take judicial notice.
Yeah. Okay, so I would ask that you
And
just
then,
take
read the
judicial
case-
notice,
read it.
case number.
Now, what you want to do when it comes to that, confirm them on Odyssey first, just to make sure
Okay.
our system didn't
Yeah.
screw up. And
Okay.
once you confirm them on Odyssey,
Judge, you,
put the case number on the record, that most judges usually find that's okay.
Let's begin. Christine Verona Green.
Your Honor, I spoke with North Broward, and they indicated to me that she's been sent down here to the courthouse.
Oh, so she's
So
not.
I don't know if she's at the main jail yet, or what's
All
happening
right, I'll
with
put
her.
it on recall. Let's see if she shows up before we're done. Thank you. Tahara Figro Suratin. Where would that be at?
Judge, I've been informed that this is a misdemeanor DV. I believe all the misdemeanor domestic violence were transported to their
Courtroom?
judge. Correct. So I've only been informed that felony DV are here.
No, all DVs are here, they're supposed to be here today.
Okay, we'll try to figure out where they are.
Maybe we should go look outside Judge McHugh's courtroom. Maybe they're sitting out there.
Yeah, Betty, can maybe you take a look-see? Thanks, I'll put that to the side. Let's see, all the, so, you wouldn't have, that would be Sunika, Karina.
Correct.
All right, let's do Gwendolyn Maddox.
She's here, Judge.
All right,
Miss Maddox, come on up, please. She's approaching, Judge.
there's nobody out there? No one in the courtroom either?
They're talking about upstairs.
No, what they mean is they were brought, the misdemeanors were brought to Judge McHugh's courtroom.
Oh, her
So
actual
they're probably
courtroom.
sitting, like, wherever they have the inmates sitting in the courtroom, and I'm sure there is a deputy up there, because they wouldn't just leave them in there. It's on the 10th floor, I don't know exact, I can find out.
But it would be in the
Madam Clerk, do you have a phone number for that courtroom?
docket, we may have it.
Can you try to call the courtroom directly and see if anybody answers? All right. I'm sorry, Miss Gwendolyn Maddox, good morning. You're here today accused of aggravated battery. The court does find probable cause. What say you state?
State would be seeking a $5,000 bond
Defense?
and no victim contact.
Judge, and speaking with Miss Maddox, she's 81 years old. My understanding is this is her first criminal offense ever. The alleged victim is a friend of hers. This allegedly happened at her home, so the alleged victim does not reside with her.
Okay.
My understanding is that there was alcohol involved. I believe the victim was also intoxicated. Having said that, Judge, she's a registered voter. She's retired. She gets approximately $850 a month in Social Security. She lives in Lauderhill. She's been residing in the same location for over 10 years. She has no problem abiding by the court's order as far as no contact with the alleged victim. But here's the situation. When she was arrested, she doesn't have her phone on her. She doesn't have a cell phone. She only has a landline. Her memory's not that good, so she has no phone numbers memorized. So she has 9 children. However, they're all grown. She has no way of contacting her kids to help post her monetary bond. She doesn't have any of her friends' contact information. For all intents and purposes, she has no way of contacting anyone. Judge, considering she's 81 years old, she's never had any sort of contact or strong ties to the community. The alleged victim doesn't live at the residence. I would ask you at this time to seriously consider releasing her on pretrial release.
State.
Now, I just add, Judge, the victim, by his own admission in the probable cause affidavit, states that they were both drinking and perhaps drank too much.
State.
And I believe the last sentence on the probable cause affidavit, when the police wanted to get a taped statement from the alleged victim, he didn't want to cooperate, Judge. So I believe there's probably going to be a waiver prosecution submitted sometime in the future. I don't know if this case is even going to be
All right.
filed.
I've heard enough. State, what say you regarding pretrial release for this elderly lady with no priors?
That's fine, Your Honor.
Thank you, so ordered. Ma'am, I'm ordering that you get an alcohol assessment, though, and that you not drink alcohol during the time that you're on pretrial. Do you understand?
Let me explain it because she's a little hearing impaired, Judge.
Sure.
The court says stay 500 feet away from her.
Yes, court order, no contact with the victim, stay 500 feet away from home, work, school, and,
The only problem with the 500 feet, Your Honor.
oh, are they neighbors?
Well, it
Thank you,
says-
Judge.
Do we know, hold on, before she leaves, does the victim live close to her? If I order no contact 500 feet?
Let me inquire.
Yeah.
Actually, I think it should be all right. See, it looks like they live in 2 different buildings. I'm looking at the addresses. One's 3751, the other's 3671.
Can always modify it to 250 if need be,
It's fine.
just so that they're not
Yeah, no, I don't have a problem with that.
connecting.
Ma'am, she lives in, Judge, she lives in,
Across the street from me.
she lives in Enderon condo. He does not live in that complex. He lives across the street.
Okay, so that would be at least 500 feet then. All right, so the court's going to order no contact with the victim and no direct or indirect contact with the victim. Make sure she understands and at least 500 feet away. So ordered.
Thank you, Judge.
So ROR pre-trial release. All right, let's see. Ashley Marie Keys.
Miss
Hi.
Keys, come on up, please.
All right, if you want, you can just come in.
Oh,
This way it's easier for you.
Thank you. All right, Ms. Keys, I do find probable cause for counts 1 and 2. Although, well, state, what say you? I mean, defense, what say you? Any? 'Cause I wasn't sure if it might be an assault.
It sounds as though the probable cause indicates that she produced a bat and struck the male half. I'm not exactly sure what that means, but
All right. Court's gonna
that
find
would
prob-
seem
yeah.
to be, in all candor, Judge.
Okay, no, because lately, because he said he grabbed it and further on, so I wasn't sure. But you're going to go with probable cause on counts 1 and 2. What say you, State?
State would be seeking a $5,000 bond, Your Honor. And no victim contact.
All right. Defense?
Judge, in speaking with Ms. Keys, she's been residing in our community for over 15 years. She's 30 years old. She's employed. She works at a post office. Been working there for about 1 year, making approximately $16 an hour. Now, the alleged victim is the father of a child. They do not reside together. She's the primary residential parent of the child. I guess they were discussing things didn't go well, and that's where we have those allegations. She has no problem abiding by her court order as far as no contact, and that's not going to be a problem.
Can
because
she
they do
afford to
not
post?
reside together.
Can she afford to post a bond?
Judge, we'd be asking you to consider $1,500 on her behalf. She first arrest ever, registered voter.
State, how feel you about placing her on electronic monitoring level 2 with no contact?
That's fine, Your Honor.
All right, court's gonna ROR her, place her on electronic monitoring, level 2. No contact
Judge,
with the
we're gonna
victim.
also request a photo order.
So ordered. No contact with the victim, no direct or indirect contact with the victim. If you own any weapons or firearms, you must surrender them.
Judge, I'd ask you to consider at this time, would you consider standard pretrial? And the reason why I say this, she works for the United States Postal Service. She's not, from what she's telling me, she's not going to be allowed to be working with a monitor on her.
Why would that be a problem if it's underneath her
have-
pants?
I'm assuming post people, they have shorts as well. We're in South Florida.
Well, I'm concerned over the level of violence that was.
Well,
Yeah.
in that case, Judge, would you just consider then a straight monetary bond, $1,500? She's been residing her whole life, no contact with the
Does she own
criminal
a
justice
home?
She actually lives, hold on one second, in Lauderhill. Let me inquire, Judge. Judge, she actually lives with her mother.
right, well, if
The
she-
mother rents the premises. Oh, she owns it?
All right,
So
well,
it's her mother's place.
well then I guess the mother can post bond for her if she'd prefer to have that. Would you like the $5,000 bond that was recommended or the EM?
Well, that's. Hold on one second. Judge, we'll take the monetary bond.
Okay, so ordered. 5,000. Anthony Bruce Bodford. Oh no, that's the misdemeanor. Sorry. Andy Ramirez is misdemeanor.
I
Misdemeanor.
think the next one would be Diego Dutra, I believe, Judge.
Violation of injunction. Is the violation of injunction would be there or not? Jeffrey Godfrey?
No, that's a misdemeanor.
Okay. All right. So Diego Potenciano Dutra.
He's here present, Judge.
Gotta remind me. Did I give you Gwendolyn Maddox? Is that the no contact order? Thank you. There you go. Was there another one that I was supposed to give you? Or are these all still on recall from before? Keys? Was it keys? Thank you. There you go, thank you. All right, sorry. Mr. Dutra, you're here today accused of domestic battery by strangulation. The court does find probable cause. State?
Just a moment, Your Honor.
What's the case? What's the case?
0900. It's gonna be 5165. And then Your Honor, and for the record, Sarah Rivera, on behalf of the state, state would be seeking a $20,000 bond in this case. He was arrested in 2009 for a battery with a different victim. He also currently, the same victim in this case has a restraining order against him.
Subsequent to
That was
this?
issued prior to this incident.
Okay.
So it looks like he may be facing additional.
Judge, I don't know if the state finished.
Believe so.
Okay, Judge, and speaking Mr. Dutra, I believe the 2009 prior that the state reference was dropped. Having said that, Judge, she's 29 years old, been residing in our community for about 25 years. He works in landscaping. He's been doing that for the past 12 years. He does live with the alleged victim. I did explain to him as far as the no contact. He will be living with his mother, who lives in a separate location about 3 miles away. Judge, we'd be asking you to consider setting a bond at $2,500. And also one additional piece of information. I believe the alleged victim and him shared 2 children in common. He's the sole financial provider of the family. What I'd ask you to do is, with the no contact order, allow for an exception to have contact for the purposes of arranging, 1, child care through a third person, and 2, to arrange for financial support so he can send money to his family so they can continue to live.
State, you have verification that there's an injunction pending, that the same victim?
We can print it out if you'd like to see.
Okay. Based on the fact that he had an injunction pending and this occurred while that injunction was outstanding and the extreme level of violence exhibited within this, the court does find that the circumstances of the event, of the offense, the weight of the evidence, that he poses a danger to the victim in this case and is gonna set bond in the amount of $35,000. And she's gonna order no contact with the victim, either no direct or indirect contact with the victim. Mr. Dutra, you're to stay at least 500 feet away from her home, school, or work. Do I have a no contact order, Dutra? You must not possess any weapons, any firearms. If you have any weapons or firearms, you must surrender them to the local law enforcement and provide proof of same to the clerk of the court. You should not possess any illegal drugs, and you should not engage in any criminal activity. Do you understand?
Yes, Your Honor.
Okay, so ordered.
Judge, in reference to the contact order for the purposes of a third person for arranging for child visitation.
Court's not gonna
and for
address that at
arranging-
this time. You can deal with that at a separate hearing.
And
In
Your
front
Honor,
of the
No problem,
appropriate
Judge.
judge.
I apologize. The state had also, I believe it also requested a GPS monitor to enforce the injunction that apparently, based on these allegations, has been violated.
So ordered. Should he postpone in the amount of $35,000, the court is also gonna order that he have a GPS monitor so that we know he stays within the prescribed limits away from the victim in this case. Right. Okay. All right, thank you. And Angela Saunders.
Angela Saunders? She's,
Hi, Ms. Saunders, you're here today because you have a violation of probation for possession of burglary tools, and you'll be for
It's actually an out-of-state hold.
from out of state, so I guess you'll be held no bond until such time as they try to either come get you or not. We'll have to wait and see, okay? Darcy Denise Hargis?
Ms. Vargas is approaching, Judge. She declined the public defender's office. She's going to be hiring her own counsel.
All right, Miss Hargis, you're here today on a KPS. I'm sorry? Oh, and your bond was already posted, so you'll be released soon. Good luck. Twinese Chantel McLeod.
Ms. McLeod is here present, Judge. She did inform me her father will be posting her bond.
Okay, I do find probable cause to the petty theft. State, do we have a Valtox on count two? Did I miss it?
I think it's actually a possession of paraphernalia.
It is a possession of paraphernalia, Your Honor, and just for the record, the defendant does have a pending grand theft auto from this year as well.
All right. Well, glass pipes generally in and of themselves aren't necessarily paraphernalia without some kind of evidence as such. Do you see something in there indicate such?
I don't see any evidence of it.
You're right. We're fine with no PC on count two.
No PC on count two. Thank you.
Is it the court
Is she posting bond at, State, are you satisfied with the $100? It's already been posted? All right, so ordered. Good
Thank
luck.
you, Judge.
I'm sorry, Shinda Monica Romero?
North Broward.
Hi, you're here today, ma'am, because you have a KPS for a misdemeanor for a trespass after warning. Bond is in the amount of $500. Do you have any questions?
Yes.
Okay.
No.
Judge, Miss Romero has been living here since she was 3 years old. She has family here. She has 4 children ranging in ages from 13 to 7, and she is a full-time mother. I would be wondering, and she's been living in the same residence for the last 6 years, which is her mother's house. Miss Romero asked if the court might consider resolving this trespass charge this morning.
I don't know the circumstances, so at this time I'm not inclined, but State, do you have an objection to putting her on pretrial if she qualifies?
Your Honor, if we just have one moment. What I'll do for something like this is, I'm just checking to see if she has prior failures to appear.
Well, she has probably at least one.
Yeah.
That's what I'm saying, if there's anything in addition to this. Yeah, she was arrested in 2016 for KPS on a grand theft auto.
Okay. Miss Romero, how much money do you have?
0.
0. Do you
Until the
work?
first of the month.
Do you work?
I have 0 until the first of the month. I'm on disability.
Ah, okay.
She had a KPS on another theft, I just don't know if she'd be a good candidate for this.
Let me see if I can look up the circumstances. Hold on. Give me a second. Is that a 7-6? I can't.
765
Thank you.
30.
Are you a mental health consumer, ma'am?
Yes.
Okay. I'm willing to resolve it. I read it. All right, ma'am, do you want to resolve your case today?
Yes.
Raise your right hand. State, do you have any objection?
No objections, Your Honor.
All right. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Tell me your name.
Shanetta Monica Romero.
Are you under the influence of any drugs or alcohol at this time?
No.
Do you understand what you're doing here today?
Yes.
Do you understand what you've been accused of?
Yes.
Do you wish to take care of it today by pleading no contest?
Yes.
All right. Do you plead no contest?
Yes.
Do you give up your right to have a lawyer represent you and to go to trial in order to get rid of that case today? You don't want to go to trial, right?
No.
And do you want to talk to a lawyer? Or do you want to give up your right to talk to a lawyer?
No.
No, you don't need a lawyer?
Yes.
All right, I'm going to go ahead and accept your plea of no contest. I find this really voluntarily given. Sentence you to time served. Good luck to you.
Thank you.
Judge, when you have a chance, I'm being told by deputies if we can call 2 people out of turn
Sure.
right now.
Court costs going to be $293. The court's going to convert them to a civil lien.
The first 2 people, Patrick Ford on page 26, so it should be second to the last page on the doc, so towards the back end of your
I'm sorry,
stack of
PD,
papers.
before her discharge, can have someone screen her for possible help? Thank you. Thank you. All right, I'm sorry, who did you want me to call?
If the first gentleman would be Mr. Patrick Ford.
He's right
on
toward the
second
very end of the
line
docket.
page.
Okay, hold on.
Page 26.
And then right after Patrick Ford, the next person is Patrick Keisel. So his paperwork should be right next to him.
Got it.
Because it's back to back.
All right, Patrick Demia Ford.
Mr. Ford is here, President Main Judge.
Mr. Ford, you're accused of burglary of an occupied conveyance, unarmed, and petty theft. The court does find probable cause. State.
The state would be seeking a $1,000 bond on count 6 and a $500 bond on count 7.
Defense, what say you?
Judge, he was here yesterday. I believe these are ad charges. I believe he currently has his $1,000 bond. From what he advised, he can't even afford that. So I just ask you to set a reasonable bond under his financial resources.
Well, I think $1,000 for a burglary is reasonable, and $500 on the petty theft. So ordered. Patrick
Next person
Ryan
would be
Keisel.
Mr. Patrick Keisel.
I believe
Patrick
he has
Keisel.
private counsel, if I'm not
And he
mistaken.
has private counsel.
All right. Mr. Keisel, who's your attorney?
Mr. Hilliard Moldov.
All right, well, he's not here right now. Do you want me to put this on recall for the afternoon and try to get a hold of him? So he can represent you at this hearing?
I was in magistrate court 2 days ago, and they were here to represent me.
All right, well, he's not here today, so we'll just, I'll put you on recall and see if he appears. If not, do you want me to reset you for the afternoon and see if I can get a hold of him?
Sure.
All right, so have a seat and we'll see. We'll try to call Mr. Hold off.
And the last person the deputies are telling me to address when you have a chance,
Go ahead.
Mr. Brian Rahim. He's on page 9 of the docket, so he's towards the front end of your paperwork.
Got it. Brian Rahim.
Okay, he's approaching right now. He was all the way in the back. Come on up, Mr. Rahim. President Judge.
Mr. Rahim, they've added an additional charge of criminal mischief between $200 and $1,000. The court finds probable cause. State.
I think, I'm just showing that, I'm just hearing the count, charge number 6, the criminal mischief.
Yep, that's what it's saying.
Yeah, we're not asking for any modification.
Okay, bond is ordered the amount of $100. Good luck to you.
Yes, Judge. Thank you.
This one's the one we have to call the private lawyer. I'll just keep it over here so I remember. Holly Ann Matson Spindler.
Northbrow.
Good morning, Miss Matson Spindler. You're here today on a KPS for a misdemeanor. Bond is in the amount of $100.
What is the misdemeanor?
Open container of alcohol.
Not me.
Not you?
No.
Well, it has Holly Ann Matson Spindler, 741 Northwest 17th Street, Fort Lauderdale.
Okay, I don't remember that.
Well, that's possible based on the alleged offense.
And Your Honor, she was in custody at the time the ticket was issued.
Okay, so they probably shouldn't have issued this if you were in custody at the time.
It's because you did not transfer to the satellite location.
All right.
I'd ask you to,
Yeah. Let me see. Do you want to take care of it today?
Sure.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Tell me your name.
Holly Matson.
How old are
Spindler.
you?
52.
Are you under the influence of any drugs, medication, or alcohol?
No.
Does anyone force you to take care of this case today?
No.
Do you understand what you're being accused of?
Yes.
Are you giving up your right to have an attorney represent you and to go to trial on this offense?
Yes.
Do you plead guilt? Do you plead no contest?
Yes.
Court accepts your plea of no contest. Court sentenced you, I find it was freely and voluntarily given, and the court sentenced you to time served. Court costing the amount of, do we know what, 70, do we know how much it is?
Okay.
For Matson Spindler? $78. Can you afford to pay $78?
Yes.
All right, how much time do you need? 90 days, okay?
Yes.
All right, so ordered. Gimel Allen. Is that back to me? Mr. Allen, you're accused of violation of probation. You'll be held no bond till you see your judge on September 26th at 9 a.m.
Okay, thank you.
You're welcome. Luz Perez.
Mr. Perez is going to require a Spanish interpreter, Judge.
All right, I'll put that on recall because Spanish interpreter is not here right now. Beatriz Tabarez.
No fraud, Your Honor.
Good morning, Ms. Tabarez. You're here today accused of possession of buprenorphine, drug paraphernalia, and you have 2 counts of probation violation of community control. The court finds probable cause on counts 1 and 2, and you'll be held no bond on the probation violations until you see your judge on September 26th. State, what's your recommendation for bond on count 1?
Convenience bond is fine, Your Honor.
Any objection to $1,000 on count 1, defense?
No, Your Honor.
So ordered, and ROR on count 2. Good luck to you.
Thank you.
You're welcome. Charlottetown Purnell Searcy. Where's that? Searcy? Nope. Which?
It might be a medical loan.
Reset?
Judge, it's a medical reset.
Okay, there you go. Terry Washington.
Mr. Washington is here at Main. Judge is approaching. He's asking Your Honor if you would consider resolving his case today.
You're here on a capias for resisting obstructing. State, do you have an objection?
No objection, Your Honor.
Yeah. Nope, not inclined based on the probable cause affidavit. Sorry. What's the recommended bond?
It's only capias, Your Honor, so.
Okay, so you don't know, so $250. Good luck to you, sir. Your next court date will be September 29th. Subnat Chattersingh.
No fraud, Your Honor.
Mr. Chattersingh, you're here today accused of resisting, obstructing an officer without violence and trespass or failure to leave upon order of the owner. Do you understand the charges you've been accused of? Yes? Okay, no, don't tell me what happened because you have a right to remain silent. So I just wanted to make sure that you know what you've been accused of. State, what say you?
Convenience bond on count 1 is fine, and a $500 bond on count 2.
All right, defense?
I think 500 on a trespass charge is rather excessive, Judge. He's gentleman 65 years of age.
All right, Mr. Chattersingh, I'm gonna order bond in the amount of $100 on count 1 and 2, and order you to stay away from 820 West McNabb Road. That's the 7-Eleven there. You are not allowed on the property at all. Do you understand? Okay, good luck to you.
Your Honor?
Yes.
Also, just to advise the court, I'm showing that Mr. Chattersingh had a trespass late last year that was, looks like it ended up getting dismissed through Judge Lorenzo's mental health court.
Yeah, you want to transfer it to?
I have no objection if you want to transfer
So ordered.
this case to Judge Lorenzo.
All right, good luck to you, sir. Taurus Antoine West. Where would be West?
Mr. West is here present, Judge?
Thank you. Mr. West, you're accused of resisting, obstructing an officer without violence, and a municipal ordinance violation. Court does.
Judge, respect, Mr. West is asking if Your Honor would consider resolving his case today.
Did you print them out? Some of them out?
Does he have any priors?
Checking that right now, Judge. His last prior was a 2007 throwing a missile into an occupied dwelling or vehicle, 2007 out of Broward.
All right. I'm inclined, if the state has no objection.
No objection, Your Honor.
All right.
Judge is
Raise
gonna
your-
ask you questions.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down, tell me your name.
Tyrese West.
Is anyone forcing you to resolve your case today?
No.
Are you under the influence of any drugs or alcohol that would affect the way you're thinking today?
No.
Have you ever been treated for a mental illness?
No.
Do you understand what you've been accused of and what you're doing today?
Yes.
And is it your desire to waive your right to have an attorney represent you and to go to trial on these charges?
Yes.
All right, do you plead guilty or no contest?
No contest.
Court accepts your plea of no contest. I do find that there's a factual basis to support the plea. I find that your plea is freely and voluntarily giving, and accordingly, I sentence you to an adjudication and time served to count 1 and 2. Court costs are in the amount of, is this a state the resisting?
Yes, Your Honor.
$293, and on the municipal ordinance, the court costs are 78. Do we know what city it is? $78. You have, is 90 days enough to pay, or do you need more time?
Yes.
90 days
90
to pay,
days.
and you have 30 days to appeal. Good luck to you, sir.
Okay.
Vladimir France Dulcio.
That's not, sir. Don't sit down. They don't have to.
Judge, I've been advised Mr. Duccio bonded.
Okay, so ordered. Ricky Farley.
North Broward, Your Honor.
Thank you. Mr. Farley, you're accused of trespassing on property that's not a structure or conveyance. Your bond is set in the amount of $25. Can you afford to post that?
No, they told me to deliver something, and that's all I was doing what the precinct said.
All right, don't tell me what happened, but you have been told not to be at St. David's, so don't go back there. Do you want to take care of it today?
Yes, ma'am.
Okay, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down, tell me your name.
Ricky Farley.
Ms. State, you have any objection?
No objection, Your Honor.
Mr. Farley, you're charged with trespassing at St. David's. Do you understand what you've been accused of?
Yes, I was just supposed to take something over there from
right.
the other church.
Well, don't take anything there anymore because they don't want you there. You're not welcome at St. David's anymore, okay?
Yes, ma'am.
All right, has anyone, are you under the influence of any drugs or alcohol right now?
No, ma'am.
Okay, do you understand what's going on today?
Yes, ma'am.
And do you wish to give up your right to have a trial and have a lawyer represent you at that trial and take care of this case today?
If the judge say so, I'm on medication for bipolar.
I understand. I want to make sure you understand what you're doing. If you plead no contest today, which means I'm not saying I did it, I'm not saying I didn't do it, but I think it's in my best interest to take care of this case today, then you would have the charge of trespass on your record, but you would be released from jail today. Or we can plead not guilty and we can schedule your case for a trial if you feel you're not guilty. What do you want to do?
Contest.
Okay.
No contest,
All right.
ma'am.
Excellent. The court accepts your plea of no contest. I do find that you knowingly until you waived your rights and that there is a factual basis for this charge, and I sentence you to a withhold adjudication and take judicial notice of credit for time served. Good luck to you, sir.
Thank you, ma'am.
Court cost amount of $293. Court's going to convert it to a civil lien.
Go with this one.
Herbie Crucell?
Mr. Cursell is here approaching, Judge. These are municipal ordinance cases.
Thank you. Sorry, wrong screen. All right, Mr. Crucell, you're here today on 3 municipal ordinance violation, no OSHA approved vests, obstructing the flow of traffic, and no safety course. Do you understand what you've been accused of?
Yes, ma'am.
All right, don't do probate.
Bond on count one is $25. Can you afford to post that?
No, ma'am. I was hoping we could resolve it today.
Does he have any priors of these? Yeah, not inclined to do that, because apparently you've done this before. So do you want to post your $25?
No, I can't. I was hoping to just get a few days to like sober up.
All right, well.
I know I'm not gonna get time served today, but.
Okay, well then the bond will stay at $25 and we'll probably see you again in a couple of days. Good luck to you, sir. Lavaris Devon Tigner.
Mr. Tigner, come on up, please.
Mr. Tigner, you're here today for a violation of probation. Bond is set in the amount of $1,500. You will see the judge on September 26th at 9 a.m. Good luck to you.
Thank you.
Julio Cesar Montoya.
Mr. Montoya, come on up, please.
Mr. Montoya, you have a capias for a trespass of a structure. Bond is in the amount of $500. You also have a violation for a municipal ordinance. Bond is in the amount of $25 on that.
Judge, Mr. Montoya is wishing to ask the court if you would consider resolving his cases today.
Hold on. State any objection?
No objection, Your Honor.
Judge is going to ask you for certain questions, okay?
That's right. He's the one that we couldn't find anything on.
All right, I'm inclined. Raise your right hand. Raise your right hand. Mr. Montoya, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, miss.
Put your hand down, tell me your name.
Julio Cesar Montoya Cañas.
Is anyone forcing you to take care of your case today?
No, ma'am.
Are you under the influence of any drugs or alcohol that affects the way you're thinking today?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
Do you understand that by entering a plea here today, you're giving up your right to have a trial and to have a lawyer represent you?
Yes, miss.
Is that what you want to do?
I want to plead guilty, miss.
All right, the court accepts your plea of guilty. I do find that there's a factual basis to support the plea on counts 1 and 2. Court's gonna adjudicate you guilty on count 2 and give you credit for time served, withhold on count 1. Court costs are in the amount of $293 and $78 on count 1. Can you afford to pay?
I'm homeless, miss.
All right, court's gonna
I don't have a job.
Court's gonna convert those fines to a civil lien. Good luck to you.
Thank you. Do I get released today?
Yes, sir.
Thank
And
you, miss.
listen
God
up,
bless
sir. Mr. Montoya, come back.
Yes, miss.
You cannot, under any circumstances, go to that 7-Eleven again. Do you understand?
Yes, miss.
Stay off
Yes.
the property, off the sidewalk,
miss.
on that side of the
Yes.
street. Walk around. Go across the
Yes,
street.
miss.
All right,
Yes,
good.
miss.
Don't let me see you
Thank
there
you, miss.
again.
God bless you, miss.
Thank you. Appreciate that. Do you have something you want?
It's the next one on you.
Okay. Nigel Dell.
Good morning, Your Honor.
What's that, man?
Oh, is that your attorney?
Apparently.
Okay, yes, on the municipal.
George Odom standing in on behalf of Mr. McLawrence. Judge, I would first ask the court, I will move to have Mr. McLawrence's firm appointed to his municipal ordinance case. I know he has 2 on your docket this morning.
All right, what did I do with that piece of paper?
Possession of a controlled substance, which I believe to be T8.
All right, so ordered.
Second, Judge, Mr. Dell, can you hear me?
Yes.
Okay, so just really briefly, I'm asking the court to get involved on if the court would consider a withhold of adjudication. If not, then I'm not going to advise Mr. Dell resolve today based on the collateral consequences that could result from getting an adjudication on count 1.
What's the controlled substance?
It's marijuana, Your Honor. It was a traffic stop and marijuana was discovered in the vehicle.
State any objection?
It's a municipal ordinance, Your Honor.
All right, I'm inclined.
Mr. Dell, do you want to resolve your case today? The court is inclined to offer you, at least on count 1, a withhold of adjudication, which will mean that your license will not be suspended for 1 year, and at least count 1 will be resolved today, and potentially you may be able to get count 2 resolved as well. Are you interested in that today?
Yes. He also wishes to resolve count 2, Judge.
You sure? Because he may be eligible for dismissal if he fixes it.
I think if he
I don't know what the status is, but, you know.
Yes, I agree. He may be eligible. Mr. Dale, do you have the financial resources of $500 to post bail?
No, I don't.
Okay,
Sir, I get paid today, but I'm not eligible to get my check.
okay.
So I don't.
Let me ask you this question. If the court, well, it's you have two outstanding cases, so I don't know if the court is going to be inclined to change those numbers. But I do want to inform you of this. You may be eligible for a program on count one, the controlled substance count, which may eventually allow that count to be dropped or dismissed, meaning that it goes away. However, if the court is not inclined to change the bond to where you may be able to afford it, you may end up staying in custody at least till September 26th, which is your next court date. But that may be an option for you. Oh, I'm sorry. I'm looking sharp. So the question is, do you want to potentially not resolve today and explore another option that you may have? Let's see, left, right. Explore another option that you may have, or do you want to just go ahead and resolve today?
I'm gonna resolve it today.
Okay, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hands down and tell me your name.
Yvonne Dell,
How old are you?
26.
How far did you go in school?
Repeat that, ma'am.
How far did you go in school?
High school.
Do you read and understand the English language?
Yes, ma'am.
Do you understand the charges that you're accused of today, which is possession of cannabis and having an unlawful license tag or sticker attached to the vehicle that you were driving?
Yes, ma'am.
Do you wish to resolve your case today by giving up your right to go to trial in exchange for a sentence of an adjudication and time served?
Yes, ma'am.
Court costs will be imposed in the amount of $293 on, these are both state, yes, $293. Do you understand?
Yes, ma'am.
Do you wish to accept that offer?
Repeat that.
Do you wish to accept that sentence as an offer to resolve your case today? Time
So
served.
explain. Yes,
You
yes,
would be adjudicated, which would be a conviction on the two misdemeanor counts. One is a first-degree misdemeanor, one is a second-degree misdemeanor. And you would be sentenced to court, to time served, and court costs would be $293.
Yes.
Has anyone forced you, threatened you, or coerced you to take this plea today?
No, ma'am.
If the court accepts your plea, there will no longer be a trial, and you can't come back and say you changed your mind. Do you understand?
Yes, ma'am.
Oh, sorry, it was a withhold adjudication on count one, so you don't lose your license. My mistake. Are you satisfied with your attorney's advice?
So I won't lose my license?
You won't. Are you satisfied with the lawyer that's representing you?
Yes, ma'am.
Do you need any more time to talk to him?
I do.
Okay, what else do you want to, talk to him privately, or do you have a question that you want to say out loud? All right, I'll put it on recall. Give him a call.
Okay, will do. Thank you, Jay.
I never even got a chance to talk to you.
Charles Teree Philpott. Hi. Oh, okay, I'll call you in a minute. The Spanish? Mr. Philpott, you're here today on a capias for operating a vehicle without having a valid license. Bond is set in the amount of $250.
Judge,
Yep.
in reference to this capias, and speaking of Mr. Philpott, he said he was already picked up on this warrant on the 13th. He was released on the 17th, and he just got picked up again on the same warrant. What I want to know is, does the state reflect in their system that the warrant was already served on him?
They be looking.
No,
Thank
that
you,
was
Judge.
a different KPS.
Different one.
Oh, different? Different one. No, it's a different one.
Doesn't really have. Failed to appear citation. Same. Oh yeah, two different fails to appear.
And just so the court's aware, when he was arrested on September 13th, it was a new DWLS and the KPS on this case separate from this one.
Yeah. All right. Bonds in the amount of $250. Good luck to you, sir.
Judge, whenever you're ready, I know we're going to do Spanish interpreter, but I know the female domestics they've been brought, and I've already interviewed them. So whenever you're ready on the female domestics, we can.
All right, let me go back to the Spanish interpreter case.
Yes,
Was
Judge.
that Luz Perez? Okay. Luz Perez. Madam Interpreter, raise your right hand. Do you swear to translate from English to Spanish and Spanish to English to the best of your ability?
I do. Good morning, Your Honor.
Good
Solange Sands.
Welcome.
Thank you.
Ms. Perez, you're here today on a capias for a felony, case number 149757 CF10A.
Señora Pérez está aquí por una orden de arresto. Es un delito de grado mayor.
Judge, she declined to serve as a public defender. She has private counsel.
La señora no ha aceptado los servicios del defensor público porque tiene un abogado privado.
Okay. Ms. Perez, you do have a right to have an attorney represent you at this hearing.
Señora Pérez, usted tiene el derecho de que un abogado la represente en esta audiencia.
Your private attorney is not present at this time.
Su abogado privado no está aquí en este momento.
Would you like me to reset this for this afternoon to see if he can become available? Is he local?
¿Usted quisiera que yo le dé un aplazamiento hasta esta tarde para ver si puede venir su abogado? ¿Él trabaja aquí cerca?
Yes, in Miami.
He's from Miami.
Okay. All right, I'll put you for the afternoon. Who is your attorney?
Le voy a dar entonces otra cita para esta tarde. ¿Quién es su abogado?
Juan Guillermo, Juan Diego Trujillo.
Guillermo, Juan Diego.
Juan Diego.
Gracias. Juan Diego Trujillo.
Yes. Trujillo, Jaramillo, I don't know.
Bueno, see, no, sorry. If I don't have his name, I don't know if I can contact him, so.
Lo que necesitamos el nombre exacto para poder comunicarnos.
I'm looking at the.
No recuerdo el apellido. Es Trujillo o Jaramillo, I don't know.
I don't remember the last name. It's either Trujillo or Jaramillo.
This might have to be resolved somewhere else. I'm looking at the transport order. She's supposed to be in front of Judge Fine this morning at 8:30 in room 4780. I'm gonna ask if you can order the deputies to bring her to Judge Fine's courtroom.
And do this as well?
Well, it's for arraignment, actually.
On this charge? Well, she has the capias.
Well, here's the thing. The capias was issued on charge 1 for failure to appear at arraignment.
Oh.
And then he did the transport order. And actually, count 1 and count 2 are the same offense.
Got it.
Parece que usted tenía también la estaban esperando en otra sala. Es con el juez Fine. Tenía que estar usted ahí a las 8:30. La orden de arresto era porque usted no se había presentado para la audiencia de lectura de cargos.
Okay. We're going to transfer you to the judge assigned to the case, so this will be heard by Judge Fine.
Así que vamos a pedir que usted la transfieran. La van a llevar a que usted se presente en frente del juez Fine hoy mismo, ¿ok?
Okay.
The
The
Judge
deputies are
Fine.
asking me if they want her to be transferred right now to Deputy Fine's courtroom. I mean Judge Fine's courtroom.
Yes, please.
Okay.
Yes.
La van a transferir
In the
inmediatamente,
meantime,
señora.
you're being held no bond until you see your judge for arraignment, which is today.
No tiene fianza en este momento hasta que se presente en frente del juez Fine.
All right, go back to the domestic violence.
Judge, we do have one more person who requires a Spanish interpreter.
Oh, okay, who else is that?
There's
I
a,
believe on page 12, there's a Mr. Reynaldo Arias Torcios.
Perfect, next one. Okay.
Mr. Arias Torcios, señor, ven aquí por favor.
Mr. Reynaldo Arias Turcio, you're here today accused of driving under the influence and driving under the influence with an enhanced breath.
Señor Reinaldo Arias Torcios, está aquí usted acusado de conducir bajo los efectos de alcohol o de drogas y un segundo cargo de conducir bajo los efectos de alcohol o drogas con un nivel avanzado.
The court does find probable cause for both counts.
La Corte decide que hay motivo fundado para los dos cargos.
State?
Vamos a ver qué dice el Estado.
State's fine with the convenience bonds, Your Honor.
Defense?
Judge, my understanding this is Mr. Arias Torcios' first offense ever. If the state can verify, we'd be asking you on count 1 to reduce it to an ROR so his brother can just post a $1,000 monetary bond on this case.
El Estado ha pedido lo mínimo y el señor del defensor público dice que ya que esta es la primera ofensa del señor, pedimos que por si acaso le podrían rebajar la fianza del primer cargo a libertad bajo su propia palabra para ver si el hermano le puede pagar la fianza que es $1,000.
State any objection?
¿Qué dice el Estado?
No objections, Your Honor.
So
No
ordered.
hay objeción, así que acepta la señoría.
Good luck.
Thank you, Judge, and if you could sign a phone order so he can contact his brother.
So ordered.
Vamos a también firmar una orden para que él pueda utilizar el teléfono.
Judge, let me inquire if any other person here at Maine requires Spanish interpreter.
Appreciate it, thank you.
¿Alguien más requiere un intérprete en español? Ven aquí, señor. ¿Alguien más? ¿Alguien más? En español. I believe in Maine, we just require, one more gentleman's gonna require the services of a translator.
There's another in North
All
Broward
right,
as
so
well.
we'll do that. So who's that?
¿Qué?
Lázaro Rego Daño.
Lázaro Rego Daño. Hugo Daño.
Rego Daño.
Go.
Lázaro?
ODA.
Thank you.
You're welcome, Your Honor.
If someone finds his page, if they can let me know.
I'm looking. Oh. Okay, Lazaro Rego, R-E-G-O, Otano.
Page 18.
Thank you, Mr. Reedy.
You're welcome, Mr. Romero.
Mr. Rego Otano, you're here today for a violation of parole. You will be held no bond until you see, I guess, parole.
Señor Regodaño está aquí por una violación de su libertad supervisada. Entonces no tiene fianza hasta que usted se presente en frente de las personas del Departamento de Libertad Supervisada.
All right, then let me go to North Broward.
In North Broward, we have Mr. Martinez Reyes for toward the end of your docket, Judge, on our page 23.
There we go. Mr. Martinez Reyes, you're here today accused of petty theft. You also have capias for a felony and a warrant violation and another petty theft.
El señor Martínez Reyes está aquí usted por un cargo de robo de grado menor. También tiene una orden de arresto por un delito de grado mayor. También tiene otra orden de arresto por violar las condiciones de probatoria de un delito de robo de grado menor.
Oh, wait, that's pretrial. That's not VOP, right?
¿Puedo decir algo?
I would like to say
All right,
something.
well, just keep in mind that everything you say is being recorded, and it can and will be used against you at this hearing and any future hearing, so I would advise that you remain silent and let your attorney speak for you.
Tenga en cuenta que todo lo que usted diga se está grabando, así que le debo avisar que todo lo que usted diga se va a utilizar en su contra ahora o en el futuro, así que sería mejor que usted permita que su abogado hable por usted.
So that you understand, you have a felony petty theft capias that was issued to you on a 16,000 case for failure to show up for a calendar call.
Entonces quiero que usted entienda que tiene una orden de arresto porque no se presentó en frente de un cargo de robo de grado menor del 2016.
And the judge has ordered that you be held no bond on that case.
Por eso el juez ha pedido que usted se le mantenga encarcelado sin fianza por este momento por no presentarse en ese caso.
It's also accused that
¿Puedo decir algo?
May I say something?
you can, but just be in mind that you do have the right to remain silent. If you do say something, it could not be to your benefit, but if you wish to say something, you may. Raise your right hand.
Okay, de nuevo quiero que usted entienda que tiene el derecho de mantener su silencio y recuerde que cualquier cosa que usted diga puede ser usado en su contra. Si usted quiere hablar, con mucho gusto lo escuchamos. Debe levantar su mano derecha.
¿Puedo decir algo?
May I say something?
After you're sworn in, do you swear to tell the truth, the whole truth, and nothing but the truth?
Después de prestar juramento, entonces usted jura que dirá la verdad, toda la verdad, nada más que la verdad.
Sí, la verdad, sí.
Yes, the truth,
All right,
yes.
be aware that you're being placed under oath, and anything you say to the court must be the truth. If it's proven that it's not the truth, you could be charged with the crime of perjury, which comes with a maximum penalty of 5 years in prison.
Ok, tenga en cuenta que usted ahora está bajo juramento, quiere decir que todo lo que usted está diciendo debe ser la verdad. Si le puede comprobar que no está diciendo la verdad, sería culpable del delito de perjurio y la pena máxima de eso son 5 años de cárcel.
¿Puedo decir algo?
May I say something?
You may.
Sí.
La última vez que yo fui a la corte, el juez me dejó ir y él no me dijo que era pretrial release, que tenía que venir otra vez a corte. A mí no me dieron papel, a mí no me dieron nada, no me llegó nada por correo.
Ok, un
no
segundo,
me dieron
señor.
nada.
Un segundo, señor. The last time that I was in court, the judge just let me go, and he didn't tell me that I was in pretrial release or anything like that. They didn't tell me that I needed to come back. I didn't get any papers. I didn't get anything, and I didn't get anything in the mail either.
Well, I can't tell you what happened on that day because I wasn't there.
No le puedo decir qué ocurrió ese día. Yo no estaba ahí.
But at this point, you failed to appear for your next court date, so.
En este momento parece que usted no se presentó en la cita que tenía en la corte.
¿Cómo me voy a presentar si no me llegó nada por correo ni nada?
How am I supposed to appear if I didn't get anything by mail or anything?
Well, I guess you're supposed to check with the clerk's office to make sure you know when you're supposed to go to court, sir.
Me adivinaría que usted tendría que hubiera llamado a la secretaria de la corte para averiguar cuándo era su próxima cita, señor.
Es que el juez me dejó ir sin papel y no me dijo que nada.
The judge let me go. He didn't give me any papers. He didn't tell me anything.
All right. Well, at this point, you're going to have to see your judge.
En este momento va a ser necesario que usted se presente en frente de ese juez.
Mr. Martinez Reyes, are you taking any medication?
Señor Martínez Reyes, ¿está tomando algún medicamento?
Yo tengo que tomarme mi medicina todos los días, si no me voy loco. ¿Tú me entiendes?
I have to take medicine every day, because otherwise I'll go crazy.
What type of medicine and why?
¿Qué tipo de medicina? ¿Por
I
qué?
got hit by a car, and they give me me dio un carro
Okay.
y me dieron
All right, Raphael, I'm going to send somebody up to see you in the next couple of days, okay?
I got hit by a car. I've been taking something. Señor Rafael, en un par de días va a ir a una persona a verlo, ¿ok?
All right. Well, he'll be held no bond on the
morfina es que me
KPS.
dan para la espalda, morfina.
I
es que
get
me
morphine.
dan para
I get
la
morphine for my back.
All right.
Para
Well,
la
yes.
espalda.
All right.
For my back.
All right. Mr. Martinez, you're going to go have to see your judge. Your attorney will help you with that, okay? Good luck to you.
Señor Martínez, usted se va a presentar en frente del juez y su abogado lo va a ayudar con eso, ¿ok? Mucha suerte.
Is there another one, or is that it?
I don't think there's anyone else. Is there anyone else in North Broward needs a Spanish interpreter?
Nobody else.
Thank you,
All right,
Deputy.
Is there anybody at Conti? Nope. Just check. Anybody at Paul Ryan? Nope. All right, back to main judge. Gracias.
Con gusto. Thank you, Your Honor. Have a great day.
You too. Tahira Figaro Suratan. That's
Ms. Figaro,
the,
come on
yeah,
up,
the
please.
domestic violence.
Your President Main Judge.
Okay, ma'am, you're here today accused of domestic violence. The court does find probable cause. State?
State would be seeking a $1,500 bond in this case, and no victim contact.
Victim advocate, do you have any input?
What's her name?
We lose our victim the Figaro Suratan. Okay. The recommendation is $1,500. What say you, defense?
Judge, my understanding, this is a cross arrest. Both of the individuals were arrested. I haven't had an opportunity to review probable cause, but usually when it's a cross arrest, it may be a mutual combat situation where, for purposes of considering the strength of the state's case, these are cases which typically probably not going to be filed because I'm assuming because of the facts of the case. But having said that, this is Ms. Figaro's first arrest ever, Judge. She's 25 years old. she's been residing,
Can she
in
afford to
South Florida
post,
for 1 month.
can she afford to post anything? Do they own a home?
Judge, no, she's a single mother. So she doesn't work. She relies on her husband,
Do they
for
own
all
a
her
home?
income. No, they're renting.
Okay.
They actually live in, I believe in Pembroke Pines. I'd be asking you at this time to consider, considering this a cross arrest, I would consider asking for an ROR on her behalf.
State, does she have any priors?
No, Your Honor.
State, what say you?
An RO is fine, Your Honor, as long as no victim contact is ordered.
Well, are they both on the docket for today, or is she first up? Because
She's the first up. The other gentleman, I've already spoken to him because I anticipated you're gonna order no contact. Basically, she's probably gonna go and reside back at their apartment. He has family here, so he's gonna reside with his brother.
okay, all
They
right.
do share a 4-year-old child, Judge, so I would ask you, they're both involved, considering, it's a misdemeanor, to allow contact, for purposes of arranging a child visitation through a third person, through
Well, at this
the
time, the
gentleman's
court-
brother.
Hold on. All right, the court's gonna order DCF to do an investigation since this incident occurred in front of the children while the child was in the vehicle. State, do you make that referral?
Yeah, I'll our victim advocate will contact.
Okay, and so at this point, they can decide what the appropriate child rearing situation should be.
So you would defer any, as far as contact,
To-
a dependency, judge could go ahead and modify anything, correct?
Correct. And at this
Okay.
time, the court is gonna order, release an armed reconnaissance, is gonna order no contact with the victim. They must stay at least 500 feet away from the victim, home, school, or work. And if she has any weapons, or firearms, she must surrender them.
Yes, sir.
Thank you. Nuninka St. Tolian.
Miss St. Toline or St. Olean? St. Olean.
St. Olean. Hi, Miss St. Olean. You're here today accused of domestic violence battery. The court does find probable cause. State.
State would be seeking a $1,500 bond in this case.
Defense.
Judge, we'd be asking for you to consider a $100 bond. My understanding, this is her first arrest ever. She's been residing in our community her whole entire life. She's working at Fort Lauderdale Airport. She was making approximately $12 an hour. Her and the alleged victim, which is the father of her child, do not live together, so there's no problem as far as abiding by a court order as far as no contact. She lives in Hollywood with her mother. Her mother works at a dry cleaners. That's why financially, her mother's the only person that can post her bond, but she financially doesn't have much resources, and that's why we're asking for what we just asked for.
Based on the allegations, the police report that the court does not find that to be sufficient to secure her appearance in court before, and the court's going to order bond in the amount of $1,500. Going to order that she surrender the firearm to the nearest police department and provide proof of same to the clerk's office. The court's going to order that if she has any weapons permits, she also surrender that as well. She's going to order no contact with the victim, no direct or indirect contact, stay at least 500 feet away from the victim's place of work, school, or home. And St. Olean, the court's going to order a GPS monitor to make sure that she abides by that condition. Karina Del Valle?
Ms. Del Valle, come on up, please. She's approaching, Judge.
Mr. Valle, you're accused of domestic violence battery. The court does find probable cause. State?
State would be seeking a $1,500 bond in this case.
Judge, I'm not saying there's no probable cause in this case, but they've been married for 19 years. They have this discussion about the issues outlined in the probable cause affidavit, and she slaps her. I think that based on her, if she doesn't have any prior contact with the criminal justice system, I think $1,500 is excessively high compared to the previous defendant who had a gun. So I think that comparison-wise, a lower bond for Mr. Valley would be more appropriate. I'd ask the court, I'm sure Mr. Romero has some more information about her ties to the community.
Just a second, Mr. Romero.
Yes, Judge.
Victim activity.
My understanding is,
Hold on, Mr. Romero.
Oh, hold on, Hector.
All right, no impact from the victim. Okay, go ahead, Mr. Romero.
My understanding, just like Mr. Reedy said, I believe this is her first contact with the criminal justice system. She's a registered voter. She works for the WIC program, which is, I guess, a program designed to help the nourishment of children. She's been doing that for about 7 months, making approximately $13 an hour. The alleged victim, as Mr. Reedy said, is her husband. The allegation is a simple slap, an open hand slap. No sort of injuries or anything like that. They live in West Park. She understands she'll have to live separate apart. She'll be residing with a friend who lives in Hollywood. The only person that can post her bond is her mother, but her mother collects Social Security. So the
Would she be interested in pretrial release?
Standard pretrial?
Yes.
Yes, she would, Judge.
State?
No objections, Your Honor.
So ordered. ROR, pretrial release. No contact with the victim. Must stay at least 500 feet away from his place of school, employment, or vehicle. Good luck to you. Anthony Bruce Bodford.
Mr. Bodford, come on up, please.
Mr. Bodford, you're accused of domestic violence, touch, or strike battery. The court does find probable cause. State?
One moment, Your Honor.
State would be seeking a $3,500 bond in this case based on the allegations.
Defense?
Judge, in speaking to Mr. Bodford, my understanding this is his first arrest ever. He's a registered voter. The alleged victim is his girlfriend. They do not live together. They live separate and apart. He lives with his parents in Fort Lauderdale. Right now, he's 27 years old, been residing in our community for 26 years. He works at Lowe's. He's been working there for about 1 month, making $10.50 an hour. Judge, I'd ask you to consider setting a $500 bond on Mr. Bodford's behalf.
Based on the allegations in the pre-exploit, the court is concerned the court's going to set bonding amount of $5,000.
Your Honor, no victim
No.
contact?
No contact with the victim. You must stay at least 500 feet away from the victim's place of home, school, or work, or vehicle. And if you have a weapon, you must surrender it. And if you have a firearm, you must surrender it. And if you have a permit, you must surrender it. Let's see.
Good luck, sir.
Andy Ramirez.
Mr. Ramirez, come on up, please. He's approaching, Judge.
Mr. Ramirez, you're accused of domestic violence battery. The court does find probable cause. State?
One moment, Your Honor. Your Honor, based on the level of violence alleged, the state would be requesting a $2,000 bond, no victim contact.
That's
Judge, in speaking with Mr. Ramirez, he's 24 years old, residing in South Florida for 5 years. I understand this is his first arrest ever. He's self-employed. He does construction, so his job fluctuates whenever he can get employment. He's been doing that for about 2 years now. The alleged victim is his wife. They live in Hallandale. He will be living separate and apart with a friend who resides in Hollywood. Judge, all I know, I haven't reviewed the PC affidavit. All I know, this is a misdemeanor offense. First contact with the criminal justice system. I'd be asking you to set a $100 bond. He has $100 in property so that he can self-bond.
Does Mr. Ramirez own a vehicle?
No, he does not own a vehicle, Judge.
Does he have any savings?
Judge, he has, I guess, he doesn't have a checking account. And he has a business account set up for whenever he does construction, that comes in that way. And I believe he told me he has $150 in that savings account.
Does the owner rent?
Rent. How much is your rent a month? $650. Okay, hold on. Judge, he rents an apartment, and his monthly rent is about $650 a month.
Who's he gonna be staying with, did you say?
A friend that resides in Hollywood.
All right, if he wants a $100 bond, it would be with a special condition of an electronic monitoring level 2.
Let me see. Yes, that would be fine, Judge.
All right, $100 bond, EM level 2. No contact with the victim. You must stay at least 500 feet away from a place of employment, school, and vehicle. If you have any weapons or weapons permits or firearms, you must surrender them.
Oh, Judge, she's inquiring when he can get his stuff. My understanding is in the no contact order should specify that he can go one time with law enforcement to retrieve his property.
It should be in the order, but if not, it's so ordered.
Thank you, Judge. Okay, thank you. Done.
Dexter Brian Sorensen.
Mr. Sorensen, here present. He's the other gentleman that was the cross arrest from the other.
All right, Mr. Sorensen, you're here today is charged with domestic violence. The court does find probable cause. State?
ROR with no victim contact, Your Honor.
So ordered.
Thank you, Judge. Okay, so ROR, no contact with that person whatsoever.
All right, you must stay at least 500 feet away from her work, school, or place of employment, and you must surrender any weapons, permits, or firearms if you own any. Yes. Jeffrey Godfrey?
Mr. Godfrey, come on up, please. Hey, good morning.
Good morning, Mr. Godfrey. You're here today accused of a violation of an injunction for protection for domestic violence. The court does find probable cause.
In that regard, Judge,
Yes.
here's what concerned me about this probable
I know
cause
what concerns
affidavit.
you.
There's an altercation between Mr. Godfrey and another person near Miss McGill. It does not occur at Miss McGill's residence, which is listed on the probable cause affidavit. In fact, it looks like it's at least several blocks away. There's no indication that Mr. Godfrey intentionally came within the area of the injunction to be in contact with Miss McGill. There's no indication that this altercation between Mr. Godfrey and this unknown individual had anything to do with Miss McGill. And I don't think that there's enough here to establish that Mr. Godfrey deliberately came within 500 feet of Miss McGill without more to show it.
Your Honor, it's the same reason why I've heard judges tell people when no contact orders are issued, if you walk into a
Right, you
Publix
see
and you
them
see
walk
the other
away.
person there, it's your responsibility to leave.
But if he's in an altercation with another person, Mr. Godfrey, I think it's very reasonable to assume, may not have had the opportunity to just walk away. There's not even an indication he knew Miss McGill was there.
I think there's enough for probable cause. What say you, State?
Your Honor, based on the, if I could have one moment, Your Honor. And just so you know, Your Honor, I'm just reviewing the petition from the injunction to get an idea of what was alleged that led to this injunction.
So he's not directly confronting the person of the injunction.
No, I understand. I'm just trying to get an idea of the level of violence that was alleged. Your Honor, there is a certain level of violence alleged. It does also involve, I can tell you that incident involved, there were other people around. It's seems somewhat similar that involved their child. I'm going to be requesting a $1,000 bond and no victim contact.
How much bond can your client afford to post?
$1,000. He can afford the $1,000, Judge.
So ordered. Tommy Lee Walden.
Mr. Walden, come on up. Judge, if I could have a brief 30 seconds to speak to Mr. Walden, he has one question for me.
Certainly. Yeah, whatever you need. Which one's already called? Oh, I forgot. Got it. Thank you. I thought you had another one. I was like, just tell me what it is. Oh, that's just fine.
Thank you, Judge, for that time.
All right, Mr. Walden, you're accused of domestic violence battery. The court does find probable cause. State.
Your Honor, the state is going to be seeking a $7,500 bond and no order of no victim contact against Mr. Walden. I'm showing 3 separate individuals, including one woman, have obtained non-expiring injunctions, orders of protection against Mr. Walden in the past. I'm also showing that Mr. Walden has a warrant from 2014 out of the state of Indiana for failing to appear in court for possession of marijuana. Noting there was also an arrest for battery in 2012 that I see no disposition. He was convicted of intimidation out of the state of Indiana. 2012, he was sentenced to 365 days with the suspended sentence of 349 days. And also noting, Your Honor, not only the alleged level of violence in this case, but that some of the incident occurred in front of the victim's 7-year-old child.
All right, defense.
Judge, in speaking to Mr. Walden, he's been resigning South Florida for 5 years. He's 27 years old. He works for Comcast. Been doing that for about, I believe, 3 years now. He makes approximately the income fluctuates. He makes on a good week about $500. The alleged victim is his girlfriend. They do live together and reside together. I did inform him Your Honor's going to order no contact. Right now he's going to just try and contact somebody as far as who he can live with, but he'll have no problem abiding by your court's order as far as no contact. He says financially he can't afford any sort of financial bond. I believe he said he may have $100 at his house. Judge, I'd ask you to take that into consideration, setting a reasonable bond on Mr. Walden's behalf.
Based on the circumstances of the alleged offense, based on his history and similar offenses in the past, and his conviction for intimidation, the court is concerned regarding the community and doesn't feel that a minimal bond will ensure his appearance in court, and the court is going to set bond in the amount of $2,500. Also order electronic monitor GPS, order he have no contact with the victim, that he stay at least 500 feet away from the victim's home, school, place of work or employment, and if he has any weapons, firearms, or concealed weapons permits, that he surrender them. So ordered. And also it's going to court refer the case to DCF for investigation, since the alleged incident occurred in front of the children. Yvonne Nigel Dell.
He's ready. George Odom again on behalf of Ms. McLawrence. He's ready to resolve it.
All right, Mr. Dell, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Put your hand down, tell me your name.
Yvonne Dell.
Is anyone forcing you to take care of your case today?
No.
Are you under the influence of any drugs or alcohol that would affect the way you're thinking today?
No, ma'am.
Have you been treated for mental illness?
No, ma'am.
Do you understand what you've been accused of?
Yes.
And do you wish to accept the court's offer, withhold adjudication on the possession of cannabis and adjudication on the unlawful license tag or sticker and credit for time served and court costs?
Yes, ma'am.
Are you satisfied with the advice of your attorney?
Yes, ma'am.
And do you wish that you give up your right to a trial?
Yes.
Do you plead no contest to both charges?
Yes.
Court accepts your plea. I do find that there's a factual basis. Court sentenced you to withhold. I find that your plea was freely and voluntarily given, and I sentence you to withhold adjudication on count 1, adjudication on count 2. Court costs will be $393. Can you pay within 90 days?
Yes, ma'am.
All right, you have 30 days to appeal. Good luck to you.
Thank you, Your Honor. May I be excused?
You may. Thank you. Juniper Rosebud.
Mr. Roseman's here, President, main judge.
Mr. Rosemont, you're accused of disorderly conduct for brawling in public and for resisting an officer without violence. The court finds probable cause. State.
State would be seeking a $100 bond on count 1 and keep in place the convenience bond on count 2.
Defense.
Mr. Roseman, it's a $100 bond. Can you afford to post that bond, or do you wish to ask the
It's
court?
200, it's 100 each count.
I believe count 1 is the standard is no bond necessary.
Well, the state's recommending to. What can you afford?
What can you afford, sir?
I had a little money in my thing, but it's already gone. It's gonna be gone now.
So you can't afford it?
My people could bond. I could call my people.
Okay, your friends will post your bond?
All right.
Your mom?
So ordered.
Judge, you can
100
afford
on count 1 and 2.
Your Honor, before we move on to the next case, do we know if they have Christine Green? I don't know, maybe they brought her, but she was in North. She was the only domestic case we have left. I don't
We
know.
have Miss Christine Green.
Oh, perfect.
Okay, did I miss one? Sorry.
On up.
Oh, yeah, I put it over here. Sorry. Christine Green. Miss Green, you're here today accused of violation of injunction for domestic violence and resisting arrest without violence. The court finds probable cause. State.
Your Honor, the state is going to be seeking a $5,000 bond, no victim contact, and should the defendant post their bond, that should be supervised by pretrial release with a GPS monitor. Ms. Green was convicted, adjudicated guilty by Judge Brown on September 14th of last year for violating the same injunction.
Defense.
Judge, unfortunately, right now she's not working. She's looking for work. She has no money in the bank, from what she advised me. She owns no property. She's asking, Judge, if you would consider an ROR on her behalf.
No. Court's going to order bond in the amount of $5,000. The court is concerned over the safety of the children. It looked like she was trying to take the children against visitation orders. Court's going to set bond in count 2 in the amount of $100.
Your Honor, as far as the request for no contact and GPS monitor?
No contact with the victim. In this case, Joseph Bryant must stay at least 500 feet away. And the court's going to order a GPS monitor.
Judge, my understanding is I believe Miss Green resides at a shelter. I believe that's what she was explaining to me, women in distress. I just don't want, I don't know if a monitor or that's going to prevent her from being released with pretrial.
Your Honor, since it's not known at that time, if there becomes at a later date where it is a relevant issue, then that can certainly be brought up before Judge McKeel.
Well, actually, we're bringing it up right now because
Okay.
it sometimes does happen. So if
All
we
right,
can
so
cut it off before it emerges.
For the record, the court is stating that the court has no objection to deleting the GPS should it be an impediment to her staying at the shelter.
Thank you.
Stefan Ross. GPS is ordered, but with no objection to review
Same count, and on those counts.
if unable to be at the shelter with the monitor.
So we just asked that this one also be set at 2,000.
Stefan Ross.
Who's the next person?
Ross?
Oh, Stefan Ross?
Oh, sorry. Conti? Hi. Stefan Ross, you're here to accused of burglary
He's got no bond holder.
of a dwelling or structure causing damage. It's an additional charge from the previous ones that you have. The court does find probable cause. State?
Your Honor, State would be seeking a $15,000 bond in this case. He has others pending as well with a $15,000 bond as well.
Is that what he got in all the
And
other?
he has multiple burglaries pending right now.
Yeah, I saw that from the police report. Are all the other counts 15 as well?
On Your Honor, every count where he was charged with burglary with damage over 1,000, they were set at 15,000. A lot of his other burglaries he's got about 20 total counts that are no bond.
Oh, okay. All right. Defense?
I think
Not gonna make it.
the request is a little excessive based on the nature of the charge, but I think that Mr. Ross has enough on his plate with all of the no bond holds that he has right now. He's gonna have to resolve that in front of his division
What does
judge.
he have
And
for
Your
no
Honor,
bonds?
well, if I could, first of all, I think it's not excessive, it's reasonable considering the nature of the charges. It's a first degree punishable by life offense. And Let's see, I've got about 1, 2, 3, 4, 5, 6, 7, 8 burglaries that he has no bond holds on. Multiple grand thefts that he has no bond holds. We're just asking the same bonds that were already set for the
Alright.
same charge.
Based on-
As I say, the request is excessive.
All right, well, over defense objection, the court does find that based on the circumstances of the offense, the penalty and weight of the evidence against him, and the danger that he poses to the community in light of all the burglaries that he's alleged to have occurred, the court's gonna find that $15,000 is an appropriate and fair bond. So ordered. John Alvin French.
That might be one of
Mr. French
those
is here present, Judge?
Might be some of the cases.
Oh, sorry.
Numbers 5 and 6.
That Maine?
Mr. French, you're here today accused on count 5 and 6, which are additional charges of false identifying yourself as a contractor and grand theft. The court does find probable cause. State?
The convenience bonds, Your Honor, are fine.
State? I'm sorry, defense? It's
No,
1,100. Okay, so ordered. $1,100.
Okay.
Mr. Patterson?
Jamal Curtis Patterson.
He's here on Main, Judge?
Oh, Your Honor, counts 2 through 4.
Yep.
Oh, wait, where's Jamal Patterson?
You have them?
You should have Jamal Patterson. over
Yep,
there.
yep, yep.
2 through 4, it looks like they were misbooked. It says no bond, but they should be hold for magistrates. They're not in custody charges.
Okay, thank you. I
I've
was
got
gonna
re-
ask you.
I got a report for defense.
Judge,
I was like,
if
there was
I can have
no-
one moment to speak with Mr. Patterson? Thank you.
Yeah, because I was gonna say there was no amounts listed. We're on Patterson, Jamal?
Yeah, this is the corrected booking for, Patterson.
That's okay.
Thank you, Judge, for giving me that opportunity.
So is Chili charged with battery?
He's charged with
Battery strangulation?
He's charged with 1 count of strangulation, 1 count of battery.
Okay.
And then the missile through
And then the throwing the deadly missile. All right. The court does find probable cause based on reading the probable cause affidavit. And what say you state?
I
Your Honor,
believe.
before the state,
Yep.
I was gonna say.
the defendant is currently being supervised by pretrial service in case 17-10255 CF 10A.
10255?
Yes, Your Honor.
CF 10A.
For a burglary of an unoccupied conveyance. He was placed on pretrial on the 2nd of this month based on the court's finding of probable cause on count 1, which is the new arrest for grand theft. We're gonna ask that his pretrial status be revoked.
What was, but this is an approximate date of June.
No, the first count, Your Honor.
Count 1, Your Honor.
There's a
grand
PC
theft.
at the front.
Oh, okay, the other PC.
Right, the other one did not violate him, but that count 1 does violate him.
Okay.
If the court finds probable cause, I'm going to ask that his pretrial status be revoked in that open case at this time.
State, what is your recommendation in addition to pretrial's recommendation that pretrial be revoked on count 1? I mean, on the
Are you asking
17
for you're asking for the bond recommendations on 2 through 4, Your Honor?
Yes, please.
Okay. Your Honor, based on, in addition to the case you were just advised of, in 2015, Mr. Patterson was convicted of uttering a forged instrument and violated his probation. He also had counts of criminal use of personal identification information and theft. 2015, possession of PVP, he violated probation. Based on his criminal history and the level of violence, Your Honor, specifically on count 3, the strangulation, the state's going to be requesting bond in the amount of $5,000 on count 2, $10,000 on count 3, $1,500 on 4, with an order of no victim contact.
Defense?
Judge, Mr. Patterson's been residing here his whole life. Unfortunately, right now, he's unemployed. He's looking for work. He lives with his mother in Fort Lauderdale. He does not live with the alleged victim, who's, I guess, the victim on counts 3. Judge, the only person that could potentially post his bond is his mother. She's a bus driver, so financial resources are not unlimited. What I'd be asking you to set is leave the standard bond in place on count 1. On count 2, I'd ask you to set a bond of approximately $1,500. On count 3, I would ask you to set a bond of $2,500. And on count 4, I'd ask you to set a bond of $500. The case 17-10255-CF10A, I'd ask you to go ahead and set a bond of $1,000 on that count, Judge.
Oh, and Your Honor, I'm sorry. Just to advise the court, the case that Mr. Patterson is on pretrial, this would be the second time he's alleged to have violated his pretrial. The previous by committing a new law offense. Last time he was held no bond.
All right, the court does find probable cause for count 1, sets bond in the amount of $1,000. The court does revoke his pretrial release on case number 17-10255-CF10A. The court feels that they're, based on his repeated violations of the pretrial conditions, that there's no reasonable conditions that the court can set to ensure that he does not violate the law while pending supervision in the community on these charges that he originally had. And is going to hold him no bond on that. On count 2 for throwing the deadly missile, the court's going to set bond in the amount of $1,500. On the domestic battery by strangulations, the court's going to set bond in the amount of $10,000. And on the battery, the court's going to set bond in the amount of $500.
Oh, and I'm sorry, I would just ask that the no contact order include the domestic violence, special domestic violence conditions.
Correct. The court's going to order no contact with the victim, either directly or indirectly, in person, electronic, by telephone, page, or fax, and they stay at least 500 feet away from their place of the home, place of employment, school, or vehicle. The court's also going to order electronic monitoring with GPS to make sure that he does not violate the terms and conditions of the no contact order.
If you ever see a case and it says Division 2B, look at the reason for the capias. If it's an unserved summons, that means the person's never appeared before the court. So you do this job. Not only get you no contact, but you go to the safes and get the victim's name, write it out, and post it for the court so they can do it. Yeah, and all you have to say is like, I'm not seeking to modify any of the bonds, Your Honor. Just
Curlings DeRosier.
Mr. DeRosier, come on up, please.
Mr. DeRosier, you're here today accused of grand theft auto, carrying a concealed firearm, excuse me, possession of cannabis, and driving a vehicle while your license was suspended with knowledge. The court does find probable cause on counts 1 through 4. State.
State isn't seeking to modify any of the bonds, Your Honor.
Defense.
Judge, his name is DeRosier. He's 23 years old, been living here his whole life in South Florida. He's a graduate of Palm Beach Gardens High School class of 2013. He lives in Wellington with his aunt. They've been residing in the same apartment for about 3 years. He just got a job. He works at Palm Beach Atlantic University's cafeteria, where he makes approximately $9.50 an hour. He doesn't think his aunt has a financial resource to post his bond. We'd be asking you to consider standard pretrial for Mr. DeRosier's behalf.
Does Mr. DeRose have any priors?
No, Your Honor.
Pardon? Yes, he does. Mr. DeRosier?
Yep.
He has a pending case off of Palm Beach right now for possession of heroin, possession of cocaine, and possession of paraphernalia. Additionally, there's a petty theft adjudication from 2013. A grand theft, I'm sorry, I misspoke, a motor vehicle without a valid license and possession of marijuana in 2013.
I've heard enough.
The grand theft of
That's okay. I've heard enough. The court's going to set bond in the amount of $1,000 on count 1. On count 2, the court's going to set bond in the amount of $5,000. On count 3, the court's going to ROR. On count 4, $750. Alfred Jackson.
Mr. Jackson, come on up, please.
Mr. Jackson, you're here today accused of giving a false identification to a law enforcement officer, but you also have a violation of parole, which is going to be held no bond. The court does find probable cause on count one, but the court's gonna ROR you on that. Good luck to you, sir. Earl King Mitchell.
How you doing?
How you doing?
Mr. Mitchell, you're to be accused of petty theft. The court does find probable cause. State.
State isn't seeking to modify the bond, Your Honor.
Any objection to $750 defense?
Judge, Mr. Mitchell has advised me he can't afford the monetary bond.
All right. State, what's his priors?
In 2016, a petty theft felony. In 2012, possession of drug paraphernalia. In 2011, he violated his probation as well as possession of cocaine. In 2011, possession of cocaine as well as another violation of probation. In 2011, a petty theft. In 2009, possession of cocaine.
All right, I've heard enough. State defense, what's your suggestion, if any?
Judge, unfortunately, he's financially indigent, and unfortunately, from what he's telling me, he has no place to go.
Okay. All right, well, at this time, bond's gonna be the amount of $750. The court has no objection to revisiting that should you find him a place at the shelter.
Mr. Crawley?
Kevin Crawley. Mr. Crawley, you're here today accused of driving a vehicle while your license was suspended with knowledge, introducing contraband into the detention facility, but you also have a probation violation, and a writ of arrest. The writ of arrest has a purge of $288. And since you were placed on probation, they're alleging that you violated that by the offense of driving while your license is suspended and introducing contraband. Did I miss that one?
There might be a second.
Where is that?
There might be a
I don't
second.
see it. We might be missing a mythical last paragraph on this affidavit.
Yeah, I don't see it. Unless it's some other charge that maybe.
Your Honor, considering that he's got the no bond hold on VOP, I have no objection. If the court finds no probable cause, the state's not gonna request any time on count two.
All right, so on count one, the court's just gonna set standard bond in the amount of $500. All right, gonna have to see you, Judge. The court's revoking bond on 14-04972 based on the violation of driving while your license is suspended. Yes?
Excuse me, Your Honor,
Yes?
that's an out-of-county VOP.
Oh, well then I'm not. So then
They'll bring
Just-
him up to.
they'll bring him up there, so I guess he's held no bond until he sees his judge there.
Judge, what I'd ask you to, on count one, would you consider an ROR so that Palm Beach can come and get him and he can address his felony violation of probation?
Yeah, then this thing's, go see his regular judge and see what the judge says. I'm gonna set bond amount of $500, because otherwise it's gonna never be
Judge, our
resolved.
second issue would be this. As you can see in count four, there's a $288
Yep.
purge amount on child support. So therefore, whoever he can contact to help post his bond, I would like those funds to be used towards the child support, not be wasted on the $500 bond.
All right,
So
well,
that's why, yes.
he can go
More
see
important
his,
things as far as in Palm Beach.
he can go see his division judge. The public defender's office is appointed, and, you can ask them. No objection to review by division judge. Anderson Bonnie.
Mr. Bonnie is approaching and declined the service of public defender.
Excuse me, Your Honor, for the last defendant, count two was ROR.
No. Good morning, Mr. Bonnie. You're here today for your first appearance. You're accused of possession of cannabis, resisting an officer without violence, and drug paraphernalia. You are entitled to have an attorney represent you at this hearing. Can you hear me? It's a little loud.
It's kind of loud.
Okay, you do have the right to have an attorney represent you at this hearing. At this time, do you wish to waive your right to have an attorney represent you, or do you want me to reset this so you can hire a private attorney?
Will I be able to get bonds?
Well, I'll have to reset it for the hearing, or you can waive your right to have an attorney represent you, or I can point the public defender's office only for the person. You just gonna waive
I'll
it?
waive it.
Okay, you're here today charged with possession of cannabis, resisting an officer without violence, and drug paraphernalia. The court does find probable cause. State, what's your recommendation for bond?
$1,000 on count 2, noting that in 2011, the defendant has a charge of aggravated fleeing and eluding. He served 15.9 months, as well as a grand theft in 99 where he violated probation and got credit for time served.
The bond is being recommended at $1,000 for the resisting an officer with violence. Can you afford to post that bond?
Yes, Your Honor.
All right, so ordered. Court's gonna ROR you on count 1 for the possession of cannabis, and on the possession of drug paraphernalia, the court's gonna ROR you on that as well. Good luck to you, sir.
Thank you.
Your Honor, here's the one order here.
Mr. Denton, come on.
What was the bond on count two?
Anthony Weechel Denton,
What was the
He's here
bond on
for-
count two?
on who?
For the last defendant, Anderson Bonnie. I just had RR on counts 1 and 4.
Count 2 was 1,000. That was the resisting with violence on Bonnie, right?
1,500.
See, sometimes it's about the wording, not just.
State, you said 1,000, right?
Yeah, $1,000 on the resisting the violence.
And then the one before that, did
Was
you decide
R-
to RR count 2?
No,
intro?
count 2 is, oh, the one before, I don't know which one's the one before that.
That's Raleigh, Judge, where you found no probable cause on the introducing a contraband into a
Okay.
detention facility.
Thank you. All right, Anthony Weedle Denton. Mr. Denton, you're here today accused of battery on the hospital employee. And there was a surrender of your bond, I guess, on another case, or
Well, yeah, Your Honor, Mr. Denton was out on bond.
on this case?
No,
Oh.
on an aggravated assault on a law enforcement officer, making threats to a specified individual and disorderly conduct. I understand that his bondsman may have surrendered his bond, but it's still within the court's discretion whether you choose to sua sponte revoke or not.
What case is that?
Case number 176243 CF10A. His other priors include 2016 battery on a law enforcement officer and simple battery. He violated probation, and in 2012 he pled a burglary up to a trespass. Based on his criminal history, the case he's out on right now, and the allegations in this case all involve either violence against law enforcement or in this case, it looks like a nurse or an ER employee. The state would be requesting a $5,000 bond.
Defense?
Judge, and speaking of Mr. Denton, he's 24 years old, been residing in South Florida 18 years. He works for Prestige Car Wash. He's been working there for about 8 months, making approximately $9 an hour. He lives in Hollywood. From what he informed me, he's been living at the same location for about 7 months with his mother. They pay approximately $250 a week to stay at that place. Judge, we'd be asking you to set a bond of $1,500 on count 1.
Based on the circumstances
And we
of
would
the,
also, I'm sorry, I
That's
apologize
okay.
to cut you off. Would you sign a photo order so we can photograph Mr. Denton's injuries?
so ordered. All right, based on the circumstances of the offense, based on the penalty upon conviction, the weight of the evidence against him, and also his previous convictions and his continuing danger that he poses to the community, the court does not feel that there are any circumstances of bond that would protect the community from his escalating behavior of violence, and it's going to revoke bond in the case of 176243 CF10A. Hold him no bond on that case. Court's going to post bond in this case on count 1 in the amount of $5,000. Jacob Joseph Delvoye.
Mr. Delvoye?
Mr. Delvoye, you're accused of possession of methamphetamine, drug paraphernalia, and then you have 2 traffic citations. I do find probable cause, however, state, looks like it's the same residue that's in the pipe that's for the methamphetamine. Do you have any other evidence of there being an actual drug other than the methamphetamine residue?
Well, other than that in his admission,
That he previously smoked it?
yes.
Okay. That would have been past possession, not current possession, but okay.
But I'm saying combined with the fact that there was something there.
Okay.
They tested positive the residue tested positive. I believe there is case law that says that defendant can be convicted with
All right.
residue testing.
What say you, defense? What can he afford to post?
What's that?
Oh, can't hear you.
Turn the mic on.
I apologize.
That's okay, you went
I
backwards.
believe this is his first arrest ever. If the state can verify, I'd ask you to consider an ROR.
Let's not go crazy.
Well, there is a presumption that a person should be released on non-monetary conditions if he's arrested not for a dangerous crime. In this case, this isn't a dangerous crime. It's a drug offense. First contact, ties to the community. He's a perfect candidate to be released under ROR according to our criminal procedure.
We'll see. What, does he have any ties? Any priors?
Not in Broward County.
Not that we see.
Alright, well, in light of his admission of using methamphetamine, I'd be more comfortable with a pretrial order
Your Honor, he refused pretrial services.
and, no, you know, with a drug assessment and no use of drugs. Because I'm concerned of his, appearing in court on a designated date should he decide to indulge in his habit again.
Judge, so he was cooperating with law enforcement by telling him exactly what was happening, and now we're punishing him for him?
No, I'm not punishing. On the contrary, I want to release him on his own recognizance with pretrial supervision with the condition that he not use drugs. I don't see how you can possibly object to that.
Your Honor, if the court is inclined to do that, we're gonna ask for an opportunity to interview him, or at least pending verification. The defendant refused to be interviewed by pretrial. He did not want to be on
All right.
supervision.
Well, that's his option. Otherwise, he can post a bond to make sure he shows up in court. Which one would you like?
Well, Judge, then we would ask you to consider a monetary bond, but the standard bond of $1,000, I believe, isn't appropriate in this situation, considering this is his first arrest ever.
How much can he afford?
I'd ask you a $100 bond on his behalf. He's a
Mr.
student. He goes to Palm Beach Atlantic. He's one semester away from graduating in psychology. So he's, I believe, he's set to graduate at the end of this semester.
Do you live?
Oh, in May.
Does your family live here, Mr. Devoy?
No, ma'am.
Where are they from?
Green Bay, Wisconsin.
Okay. How long have you been here?
I have been a student since September of 2013. I took a semester off last semester to receive treatment for my addiction. I'm going back into treatment this week because I do have a drug problem.
Don't talk about
I apologize. So there's that.
All right. So do you have any savings?
No.
Do you work?
Yes.
Where do you work?
In Delray Beach.
Doing
at a restaurant as a server.
Okay. Court's gonna set bond on count 2 in the amount of $500. Court's gonna RMR him on count 1. Good luck to you, sir. Court's gonna order no illegal substances as a condition of your release. Julian Felix Hernandez.
Your Honor.
Mr. Hernandez, you're here today accused of possession of MDMA, possession of 2 other controlled substances without a prescription, and you also have alleged violation of probation. Because you are on probation for trafficking and stolen property when you have allegedly violated the law by these charges. The court does find probable cause on counts 1, 2, and 3. State, he is on probation. What's the case number?
So it looks like it's out of Palm Beach, Your Honor.
Okay, so I won't deal with that then. Can I?
I'm sorry?
Can I deal with the Palm Beach?
I believe it's really for that in that judge's
All right.
jurisdiction to.
So ordered. So what is your recommendation, state?
We're not asking for any modifications, considering it's at the no bond VOP out of Palm Beach County.
Okay. Defense?
That should be easy to do. So you might want to just.
Judge, Mr. Hernandez advised me he's on disability. He has some medical issues. The only person you can contact is his sister to oppose his bond, but he doesn't think that she could afford the monetary bond. This probation case is out of Palm Beach. Judge, the alleged allegations here is drug offense, nonviolent offense. As we know, it's probably going to take over 30 days for the state to file charges, so they're not going to have charges filed in time. So most likely what's going to happen on the 33rd day, he'll get ROR, and then Palm Beach will come and get him. I'd ask you, let's save ourselves the 33 days, and if you would consider an ROR on his behalf at this time, so Palm Beach can actually pick him up
on his probation felony offense.
You're on probation, we're not picking him up until there's an active warrant, it's a 940 agency.
Correct. At this time, where does
can't
he,
hear
where,
you. Who
where,
was speaking?
they're saying they're not gonna pick him up until there's an actual warrant. At this time, where does he reside?
Where do you reside? With my sister. Judge, he resides with his sister in Margate.
In which county? In Broward County?
Broward.
Okay.
Broward.
And does your sister own a home? Or does she rent?
She owns her husband.
Okay.
The probation's in Broward.
Your Honor, just to advise the court, and I understand Mr. Romero is arguing that these charges are nonviolent. He was just arrested in June 24th for an out-of-county hold on the same case as the out-of-county. And I know it shows trafficking stolen property on the booking sheet. The other charges: grand theft, false verification, and tampering with a witness or victim.
Based on his history, his alleged violation of the law, which the court's finding probable cause while he's out on supervision, and his continued violation of the law, the court is gonna set bond in the amount of $1,000 on each count. Aaron Flores.
Mr. Flores, come on up.
Good morning, Your Honor.
Good morning. You're here today accused of violation of probation. You're going to be held no bond until see your judge on September 26th. Dominique Collier.
Mr. Collier's here.
Mr. Collier, you're also here for a violation of probation. You'll be held no bond until see your judge on September 26th at 3 p.m. Is that a 3?
Good luck, sir.
That's a 3, right? I can't tell that. Is that backwards? What time is that?
Well, I think it's
Can you see that? Is that at 8:30 or is that 8:30? 8:30
8:30
a.m., sorry. Couldn't tell. Johnny Eugene.
He's here at Maine.
Mr. Eugene, you're here today accused of violation of probation, and you also have a KPS for another felony case. For possession of cannabis, you're going to be held no bond on both counts until you see your judge on the 26th at 9 a.m. Jason Lang. Mr. Lang, good morning. You're here today for a violation of probation. You're going to be held no bond until see the judge on September 29th at 8:45. Good luck to you.
Yes, ma'am. Thank you.
You're very welcome. Joseph Paul Doika. Does that mean? Mr. Doika, you're here today for a violation of probation on 2010 case. You're going to be held no bond until September 26, 8:30 when you see your judge.
Thank you, Your Honor.
Welcome. Jordan Guy Torres.
Torres?
Mr. Torres, you have 3 counts of violation of probation. You're going to be held no bond on all 3 counts and to see the judge on September 27th at 8:45. Desmond Santano Ennis. Mr. Ennis, you're accused of unlawful possession of the personal ID of another, 5 or more, fraudulent attempt to use that ID of another person without consent, failure to register the vehicle, and then you have 2 counts of violation of probation, which will be held no bond until see the judge on September 26th. State on count 2. That would be an attempt to use. Was he, is planning to attempt to use, or because I don't know if he was actually. He says he was going to. He was going to. I'm just asking. He had intentions of, but I don't know that he was actually in the process of.
Your Honor, I think the, one moment.
Don't you have to at least be trying to use it for the crime?
That's what I'm looking under the statute. Yeah, Your Honor, reading from the statute, 817.5682A, any person who willfully and without authorization fraudulently uses or possesses with intent to fraudulently use.
All right, so I guess that will be PC then. All right, court finds PC on counts 1, 2, and 3. What's your recommendation?
No modifications, Your Honor.
All right, state, I'm sorry, defense? Other on counts 1, 2, and 3?
Considering as a no bond hold on the BOP.
All right, so ordered 1,000, 1,025. Good luck to you, sir. Travis Lee Robert Miller? Mr. Miller, you're accused of possession of cocaine, resisting and obstructing an officer without violence, 2 counts. And you also have a probation violation, which will be held no bond until 9/26 at 9 a.m. when you see your judge. State, what's the recommendation on counts 1, 2,
Your Honor,
and 3?
Mr. Miller is currently being supervised by pretrial services in case 16-13697 CF10A.
13697.
CF10A, 1 count of grand theft auto, 1 count of resisting without violence, 1 count of leaving the scene of an accident, 1 count of petty theft, and a count of operating without a valid license. Based on this new arrest and the court's finding of probable cause, we're gonna ask that his pretrial status be revoked at this time.
Defense, anything to add? All right.
Judge, considering he's
He's
being
already
on no
been held.
bond, count 4, we defer any argument at this
All
time.
right, okay. Court's gonna revoke, pretrial release on case number 16-13697 CF10A, based on the court finding probable cause to counts 1, 2, and 3. I'm gonna hold him no bond on that charge. Court's gonna, postpone the amount of $1,000 on count 1, and, $500 on counts 2 and 3, in light of the fact that these are repeat offenses for the same offenses.
Thank you.
Desmond Mano Mueller?
Yes, ma'am.
Hi, you're here today charged with, you're here today charged with 3 counts of grand theft, 3 counts of dealing in stolen property, and 3 counts of false owner information when you pawned items that were worth $300 or more. The court finds probable cause to all 9 counts.
Yes, ma'am.
State?
State doesn't seek to modify the bonds, Your Honor.
Defense?
Judge, the only thing on counts 4 through 9, we'd ask you to consider reducing it from $3,500 to $1,500. At this time, he's working at a warehouse, making approximately, he gets paid by the day, about $80 a day. He's been doing that for about a year. He lives in Hollywood with his friend. The person who's going to be contacted to post his bond is his sister. She lives in Broward County. He's hoping that she could afford this bond. So that's why we ask you to reduce the bond accordingly.
State, does he have priors?
That's what I'm checking right now, Judge. Was he arrested for? I know he was arrested. There's a traffic matter. I gotta see if that's still open. Just showing a, misdemeanor cannabis paraphernalia he pled out of June of this year.
All right, so no prior thefts.
No.
All right, court's gonna set bond in all counts in the amount of $1,000.
Thank you, Judge.
Peter Allen Haas.
I've been advised of medical reset, Judge.
Brian Michael Consalvo.
Mr. Consalvo is here present, Judge.
Mr. Consalvo, you're here today accused of obtaining a controlled substance by fraud, and you're also accused of violation of probation. There's a warrant. Active Catheus. That was this one. Is that because he was on probation for the same thing?
He's actually on probation out of another state, Your Honor. He had his probation transferred to Florida. He's out of probation out of New Jersey.
For the same offense, or?
Yes.
Okay. All right, court finds probable cause. State, what's your recommendation?
No modifications, Your Honor.
Defense?
Judge, considering it has a no bond hold, we defer any argument at this time.
All right, bond in the amount of $1,000, no bond on count 2. Philmon Lee Bell.
Mr. Bell? Come on
Outside, sir.
Question of state, is the shed a dwelling or is that a structure? Like it's on the property of the, it says located on the first floor of the same structure, so I don't know, is the shed connected to the
Well,
house?
no, I guess what I'm.
Because then the apartment's upstairs.
I'm inclined to agree with you, Judge. It doesn't seem to fit the traditional definition of what a shed would be.
You know what, it's probably a storage locker that usually the apartments have. You know how they give
Probably
you-
is not
I know, I'm
exactly
just, well, because,
probable cause,
well, the
though.
problem you have is that they're saying it's attached.
I
And they're,
understand.
you know, not separate, so that's the problem we're having. I don't know if you want clarification, but,
And that's the thing, I'm gonna check one thing to see if it's even worth,
because of the apartment, yeah.
Your Honor, I'm fine with structure.
All right, court finds probable cause to burglary of a structure.
I just have one moment to review his criminal history.
And petty theft.
Okay, his criminal history includes 2015 possession of PVP with a violation of probation, resisting without violence and trespass 2015, delivery of cocaine 08 with a VOP.
That's what history Doug used.
Uh,
Any other burglaries?
Not. Theft in 02, I'm not
All
showing.
right, that's kind
any
of far away.
burglaries.
All right, what's your recommendation?
Your Honor, state would be requesting a $5,000 bond, no return to the property.
Defense?
Judge, and speaking to Mr. Bell, he's been residing in South Florida his whole life. He's 34 years old. He works for a company called Southeast Design Construction. He's been working for them for about 1 year, making about $12 an hour. He lives in Pompano Beach. The arrangement he has is he lives at a church. It's called Christ Church. He volunteers at the church, and they in turn allow him to live there. He has, I believe, his contact person at the church is a person by the name of Pastor Richie. What I'd be asking you to consider, Judge, considering he has no prior burglary offenses, is if pretrial can verify as far as where he's staying, if he could be released on standard pretrial.
State if I include a condition that he get a drug evaluation, no drugs or alcohol, and random testing, would you have any objection to that?
I would, Your Honor. If
Okay.
this was strictly a structure with no connection to someone's home, that would be one thing. But considering that there is, even though it does, I have no objection to PC for structure, obviously.
Right.
It is still connected to someone's home. Early evening, people were home. This could have gone a lot worse. I think some monetary bond would be appropriate.
I don't know that he can afford. Problem I have is that I would feel more comfortable, you know, for the community if he could be on a monitor, but because he's with the church, that's probably not gonna be possible. This is what I'm gonna do, I'm gonna set bond in the amount of $1,000 to see if the church can possibly help him out. If not, I have no objection to having another court review it, okay? If the church comes in, if they're willing to, you know, provide some alternatives.
Judge, would you sign a photo order as well?
Yes.
Thank you.
Was that photo or phone?
Photo.
Cardenas, Linsky, Gaspar.
No, they still treat it.
Oh, and no return to that location, Mr.
His bond has been posted.
Lindsay.
Yes. Mr. Gaspar is here, present judge at Maine. He declined to serve as a public defender.
Mr. Gaspar, yes?
Oh, his bond is posted.
Mr. Gaspar, you're here today for your first appearance where the court's gonna determine if there's probable cause for the charges that you're accused of and what appropriate bond should be set. You do have the right to be represented by an attorney. At this time, if you do not wish the services of the public defender, do you wish to hire a private attorney or do you wish to represent yourself?
On a private, can I use the public defender for now?
Yes, you may.
Sorry.
PD,
Okay, I'll have him go ahead and
you're
if we can put
reappointed.
our recall so we can fill out all the paperwork and everything like that, Judge?
All right, you're gonna be appointed certainly for the purpose of this hearing then. The court does have, the court does find possession for THC and possession of cannabis less than 20 grams, and drug paraphernalia. Apparently it was a cartridge. State, what say you?
State isn't seeking to modify the bond, but I believe the bond's already been posted.
Oh, okay. Apparently your bond's already been posted, sir.
Okay.
So bond in the amount of $1,000, ROR on count 1 and 2. Good luck. David Maurice Daniels.
I've been advised he bonded, Judge?
All right, court finds probable cause, bond in the amount of $750. Juan Jose Rodriguez Fajardo.
Come on up, sir.
I'm sorry?
Count one was corrected to state of emergency.
Well, it should also be dwelling, but.
I don't know.
All right. All right.
Yeah, see, that's the funny thing. If you look at the statute actually says dwelling structure or
All right, Mr. Rodriguez Fajardo, you're here today accused of burglary of an occupied structure or dwelling during the state of an emergency and grand theft. The court does find probable cause. State.
Your Honor, from what I can see, the only prior risk Mr. Rodriguez has is a 2006 trespass within a school safety zone. That being said, I believe that the allegations in this case and the strength of evidence against Mr. Rodriguez Fajardo are just so overwhelming that I'm going to be requesting a $25,000 bond and no victim contact. One of the potential consequences he faces is that this was allegedly committed during a state of emergency, makes it a potential first-degree felony. What he was accused of stealing, a generator that a mother was using to provide power for 3 children who were disabled. And his explanation for why he took it is because he wanted power. I find to be very disturbing, Your Honor.
That's.
Judge, in speaking to Mr. Rodriguez Fajardo, he's been residing in South Florida 12 years. He's 34 years old. At this time, he's not working. He's looking for work. He was employed approximately 4 months ago. His company, unfortunately, laid him off. So at this time, he's looking for work. He was making about $500 a week. Since he's been laid off, he hasn't obtained employment. He's been looking. He's been forced to basically go back and live with his mother. So right now, for the past about 4 months, he's been residing in Fort Lauderdale with his mom. From what he told me, his mom cleans houses for a living. So as far as the financial resources, as far as the $25,000, it's simply tantamount to no bond for his particular financial resources. He did advise me as far as he has limited contact with the criminal justice system. He's a registered voter here in Broward County. Judge, I understand the nature of the allegations. However, at this time, Judge, we'd be asking you to consider setting a bond somewhere in the neighborhood of about $2,500.
Does his mom own or rent?
Let's see.
She rents and her mom rents the apartment, and he doesn't know as far as how much is the rent.
Mr. Rodriguez Fajardo, you show a complete lack of foresight in consequences of your actions, and the court does find reprehensible what you did because these children were disabled and you don't know what effects their not having electricity could have had on that family, thereby posing a great danger to the family that did provide for emergency services for their family. So the court is concerned that based on the circumstances of this offense, the weight of the evidence against you, and the possible sentence that you may be imposed, in light of your financial resources, your lack of employment history, your lack of judgment, the court is concerned that a minimal bond will not ensure your presence in court. And therefore, court is gonna set bond in the amount of $25,000 on count 1 and $1,000 on count 2. So ordered. Michael Ian Bugter Van Loon. Mr.
Judge, if I could have 1 moment to speak to him, please? Sure. Thank you.
I have some pretrial orders here, like no contact that I didn't sign. I don't know if we called these or not. We'll have to go back and check these 4. Since I don't have a docket to go back and check.
This time the gate was fully open, like being accepted at the car church. Officer Mom had to move quickly to a regular workbench.
Mr. Reedy, did you have a number for Mr. Moldoff to call for Mr. Kiesel? Per chance?
Thank you, Judge.
All right, Mr. Victor Van Loon, you're here accused of fleeing, eluding a law enforcement officer, aggravated assault on 2 counts against a law enforcement officer, aggravated assault on a person 65 years or older, battery on a person 65 years or older, resisting, obstructing an officer with violence, and count 7, tampering in the 1st degree. Court finds probable cause counts 1 through 6. State the tampering.
Of 5,000.
What was the tampering?
Your Honor, tampering would be. Yes, Your Honor, it's the second full paragraph. It's tampering or preventing. The statute also covers preventing someone from calling 911.
Okay, then that's what, then the court would find probable cause for that. Okay, thank you.
But it looks like it should be tampering in a 3rd degree felony. And I note that's significant because tampering in a 1st degree felony is actually punishable by life.
All right, so the court's correcting that to interfering, finds probable cause in a 3rd degree felony proceeding. What is your recommendations on counts 1 through 7?
I'm wanting to, you're fine with the standard bond. Let the judge know.
We only got a standard on, well, the recommended bond on count 1 is 2,500, and then the others are to be set.
We're fine with 1.
Okay.
On counts 2 through 5, the state would be seeking a $5,000 bond. And 6 and 7 will leave to the court's discretion.
Okay. Defense?
Judge, I've been trying to talk to Mr. Bogder. At this time, he's advised me he's not working. He lives with his parents in Pembroke Pines. He said I believe his mother is a teacher. That's who's going to be posting his monetary bond. I tried to get into his financial resource if he owns any property or anything like that. He doesn't have any money in the bank. Judge, I believe there are some issues that the defense will explore as far as potentially looking into his mental health.
Does the mom own or rent?
Yeah. I don't. Right now, I wasn't able to ascertain that information. I think there's some.
Okay.
There are mental health issues, Judge.
Okay.
So, Judge, that's why I'm in a vacuum as far as the information relating to his parents' financial resources, Judge.
All right. State, what was your recommendation? It was $5,000. That counts 2, 3, 4, and 5?
2, 3, 4, and 5, Your Honor, yes.
All right. Court's gonna put on that, counts 2, 3, 4, and 5. On count 6 and 7, 1,000. And the court has no objection to review by the assigned judge in light of further information that may come to light.
We would also ask for no victim contact, Your Honor.
There are officers. Oh, no, who
No,
was the 60?
his
no,
father.
No, oh, that's his father? That was right, that was his dad. Oh, did the dad victim advocate, do we know if dad wants no contact with his son?
It wasn't, Your Honor, it wasn't, since unfortunately it wasn't put with the domestic violence cases, it wasn't.
Doesn't know?
She only picks
All
up the
right,
packet that are
no
domestic
contact with the victim in this case. Subject, and no objection to review if the victim doesn't wish it.
Your Honor, what are the bonds? I'm sorry for,
2, 3, 4, 5 is 5,000, and then 6 and 7 is 1.
oh, thank you.
All right, what was first? That's not one of these either, right? No, okay. Brian Keith case.
Yeah.
Mr. Case is here, present Judge at Maine. He declined the service of public defender.
Mr. Case, you're here today for your magistrate hearing where the court's gonna decide if there's probable cause on 6 counts. Well, actually, on 3 criminal charges, then the others are not criminal. And then the court will have to decide what the appropriate bond is. You do have the right to have an attorney represent you and give you advice on your behalf at this hearing. At this time, do you wish to represent yourself, or do you wish me to reset this so that you can contact an attorney to represent you? Or do you want to reconsider letting the public defender represent you?
I'll go by myself right now, ma'am.
Okay, at this time, you're accused of child abuse without great bodily harm, driving under the influence, and driving with a license, a vehicle while your license was suspended with knowledge. The court does find probable cause to all 3 counts. State, what is your recommendation?
Your Honor, the state's gonna be recommending bonds on count 1 and 2 at $5,000 each. Should he post his bond, that he be supervised by pretrial release, so that there could be alcohol and drug testing and monitoring. Mr. Case's criminal history includes 2015 out of domestic violence court, battery, and resisting without violence. He just had his probation terminated late February of this year. Disorderly conduct 2013, possession of cocaine and reckless driving 2012, he violated probation. In 2009, a battery. In 2009, assault on a law enforcement officer. And 2006, leaving the scene of an accident. And when he committed that offense, he was driving without a valid DL.
All right. What would you like to say? If anything, keep in mind that you do have a right to remain silent. Anything you say can and will be used against you at this proceeding or any future proceedings, so I advise you not to speak about the circumstances or facts of the arrest. But if you have anything you want the court to consider regarding the monetary bond, I'm willing to hear it.
I'm going. My grandmother just passed away last day before the other 2 days ago on 9:00 p.m. I'm going to have to be going to Tennessee for the funeral and everything. So hoping that I can get that lifted until I get returned. I'll be up there for a solid of a week and a half.
How much monetary bond do you feel that you can afford, sir?
I can afford up to $8,000, ma'am.
Okay. And at this time, are you working?
I am self-employed, ma'am.
Doing what?
Remodeling and property management.
Okay. And how long have you been in Broward County?
For over 20 years.
Okay. All right, court's gonna set bond in the amount of $7,500 on count one, $500 on count two, ROR on count three.
And, Your Honor, we are going to ask until further order of the court that there be an order of no victim contact with the alleged juvenile victim, and we are going to be contacting the officer. Since we don't have any information about the child, we're going to contact the Davie officer that made the arrest to make sure that if he hasn't already, that he'll contact Child Protective Services.
Well, the court's gonna order that Child Protective Services be notified of this incident. Court's gonna order also that he be placed on pretrial release should he post the bond. Special condition, no alcohol, no illegal substances, and random testing at the discretion of pretrial release. And no contact with the victim in this case, which is the child, until such time as approved by either Child Protective Services or another court of jurisdiction.
He's permitted to work on electronic
Yes,
monitoring level 2.
I'm not doing E, I'm just PTR.
Standard.
Yeah, standard.
Yeah, and I wasn't asking
Yeah.
for...
All right, good luck to you, sir.
Judge, before we go on to the next gentleman, before I forget, on the previous gentleman to this gentleman, Mr. Michael Bugder Von Loon.
Yes.
Would you sign an order appointing the public defender's office to his case?
Yes, so ordered.
Thank you, Judge.
Watt Thomas?
Mr. Watt Thomas is here, present, Judge at me.
Mr. Thomas, you're accused of possession of cocaine. The court does find probable cause. State?
Your Honor, Mr. Thomas has a lengthy record, but I'm not asking for any modification.
And defense?
Mr. Thomas asked me to ask Your Honor if you would consider an R1.
Your Honor.
What's his history?
Okay.
If it's lengthy, keep the most recent.
Most recent. Say 2011 grand theft. He was adjudicated guilty, sentenced to 5 years probation as a habitual offender.
All right. Does he have any previous recent failures to appear or drug offenses?
I'll check, Your Honor.
In the meantime, while they look at that up, Mr. Thomas, can you afford to post any bond?
No, not right now.
Do you own a home?
Do I own a home?
Yes.
No.
Do you work?
Yes, I remodel homes.
Okay. Do you have any savings?
No.
Do you have a car?
Yes.
How much? What kind of car?
A 2002 Chevy Blazer.
All right. Well, that should be worth at least $1,000 or $850.
Your Honor, I'm showing he was arrested. Okay. His most recent arrest was July 23rd of this year for a violation of probation.
What was he on probation for?
The grand theft that he was...
Oh, from back before?
I'm just checking
okay.
to see...
What the violation was for?
Yes.
That's what it is, pretty low.
Failure to report, failing to make restitution.
All right.
And he, Judge Fine terminated his probation. I think he was released August 10th.
All right, Mr. Thomas. I think you can afford, based on the fact that you own a vehicle, the bond at $1,000 if you go through a bondsman. So good luck to you. Antonio Michael Nunali.
He's here present, Judge?
Mr. Nunali, Yeah, he has,
Oh, I'm sorry.
that's okay, you have 4 counts, 3 warrants for violation of pretrial felony, and then a KPS for traffic. What's going on?
He wants to know the allegation as far as how, the nature of the violation of pretrial.
Let's try to figure that. Let's see. By failing to remain confined to his residence at all time except for those times pre-approved by the pretrial program personnel in Broward County, Florida on September 4th, 2017, between the hours of 10:54 a.m. and 11:08 p.m., the defendant left his residence multiple times without permission. His activities and whereabouts are unknown. That's the allegation. Count 1 is no bond. Count 2 is 1,000. Count 3 is 1,000. And then on the KPS for the traffic bond is $500. Good luck to you, sir. Leon
Judge,
Gregory
he's
Johnson.
currently on a bond. When did this? Here. So you want me to tell the judge?
Oh, Judge, I've been advised Mr. Leon Johnson is in regular court right now.
For these charges or something else, do we know?
Something else.
I have no
All right, so
idea.
what do I do with him?
You can reset for the
All right, let's do it for the afternoon and see if he comes. Okay. Nestali Torres. Mr. Torres, you're here today for a violation of probation. You'll be held no bond until September 26th at 8:30 when you see your judge. Good luck.
Thank you, Your Honor.
Welcome, Cheyenne Adams.
Mr. Adams is here approaching Judge Amin.
Mr. Adams, you're here today accused of aggravated fleeing with serious injury or death, operating without a valid license, grand theft auto, resisting obstructing an officer without violence, and operating a vehicle without having a valid license. State, I have a question on count 4.
Yes, Your Honor.
I mean, is that a separate resisting other than the fleeing?
I'll check. I'll check. I can tell you it's been filed.
Okay, so there must be
these-
something there.
Yeah, they're all direct filed. While I'm checking, Your Honor, I can tell you, and I spoke with Assistant State Attorney Linda Berman. There's already been an order, because Mr. Adams was in a juvenile commitment center. Judge Siegel signed an order to bring him to his courtroom. My understanding is I believe it's gonna actually be resolved on Monday. He really can't go anywhere, so we're just here to set bonds because he's legally entitled to bonds.
Okay.
He'll go back to Jack when we're done with the hearing this morning.
I just didn't, I don't know if I.
No,
didn't
of course,
see
I
it.
understand. And, Your Honor, the allegations are.
Your Honor, count 2 is corrected,
To be,
to reflect, it's booked as a citation, it's corrected to reflect a 3rd-degree felony.
operating without a valid?
Yes, that's.
As a felony? I'm not familiar with that felony.
No, it's.
I went by the instruction sheet.
Wait, you said count
2?
5? Or which, you said count 3? Yeah, DWLS works here. She's not talking about the operating without, it's count 2. The,
Oh, so they changed it to
DWLS.
DWLS, okay.
It's DWLS causing serious bodily injury or death.
Okay, no, that's not what it says on my thing.
Yeah,
That's
I know.
what
Yeah.
Operating without.
Yeah. Your Honor, the allegation in the information is that he obstructed or opposed a sergeant making an arrest by fleeing on foot.
Oh, so yeah, that wasn't in the PC.
Yeah. Your Honor,
So-
the state would be requesting
All right,
$10,000 bonds on 1 and 2.
all right, what say you, defense?
Judge, he's 16 years old. He's not working. He goes to Taravella High School. He lives with his father in Sunrise. His father rents. They've been renting this at the same apartment for about 1 year. He told me that his dad works in construction. He doesn't know how much the rent is or how much his dad gets paid. Judge, as far as his financial resources, he owns no property, no sort of money in the bank, nothing he could sell or anything like that. I'd ask you to take that into consideration determining a reasonable bond.
Based on the circumstances of this offense, with the serious injury, the likelihood of the weight of evidence against him, the penalty upon conviction. The court's gonna set bond on count one in the amount of $10,000. Count two, the court's gonna set bond in the amount of $5,000. And the court's gonna set bond in the amount of count three, $1,000. RR him on count 4 and 5.
Judge, one other question. He has a question about. I believe Mr. Lender says that he will be taken to court on Monday. He's just inquiring about that.
He'll be going to Judge Shiegel's courtroom on the 25th.
So then it'll be handled. And does he have any other juvenile holds or anything like that? Where
Yes, he'll be in the detention center until then.
Okay. So that's
All right, so Leon Gregory Johnson is reset for the afternoon, and Patrick Kiesel is also reset for the afternoon.
Yeah, we have one last case, Your Honor. So it's listed as a perfection.
Okay.
They just didn't have the affidavit yesterday. I have the affidavit for the defense and the court right now.
What was the perfection?
It's they just didn't have the affidavit yesterday, Your Honor.
Oh, okay. All right. The court does find probable cause based on my review of the affidavit for counts 1, 2, and 3. It's recommended that he held no bond, obviously, on counts 1 for attempted murder in the first degree, actual possession, discharge, great bodily harm. He's also charged with armed burglary of a dwelling, which he also be held no bond. The court does find, unfortunately, based on the fact that the court finds probable cause, after reviewing the affidavit, I find that proof of the guilt to be evident, or that the presumption is great, that you can well be convicted of this offense based on the information provided and the identification made, and accordingly, you'll be held no bond as counts 1 and 2. What is the recommendations on count 3?
Your Honor, I'm fine with the bond that Judge Roballo said on count 3. The only other the only other condition I would be asking for is an order of no victim contact.
State, defense, anything else you'd like to add?
Yes, Your Honor, we would object to the court making a finding of proof, evident, presumption great based on this affidavit. That's the highest standard of proof we have in the criminal justice system, higher even than proof beyond a reasonable doubt. The state is asking the court to hold Mr. Pitts under the most severe pretrial detention conditions, yet they've introduced no evidence, they've called no witnesses. All they provided the court with is an affidavit, and we would ask the court, since the state has failed to reach the burden of presumption, of proof, evident, presumption great, we would ask you to set a bond for Mr. Pitts.
The court does note your concerns, and as a result, the court is gonna enter this order without prejudice to the defendant to file a motion to set bond within his assigned division, and he can request a hearing under State v. Arthur, and no objection from the court should that court, based on the evidence provided, choose to set a bond in that case. On count three, the court's gonna set bond in the amount of $10,000.
Before we adjourn, Your Honor, and I think that was the last case, if I'm not mistaken.
I believe so.
I received a call from our office while we were at the latter part of our docket from Miss Nadine Geralt. She has a young person in jail right now who has been here and kind of delayed from getting out of here because of the hurricane. He's charged with a third-degree felony, and she's wondering if there's any way we could get him on this afternoon's 1:30 docket.
Any objection?
Well, is he a juvenile?
I don't think so. His name is Keenan Seymour.
'Cause, I mean, there.
I haven't had a chance
I just would want a
to.
little bit more information than.
Yeah, well, listen, you
I have
guys,
the case number.
you guys talk, and if the state has no objection, put it on.
All right.
Otherwise, I don't know if it's an assigned judge or if it's a case that's already pending, I don't wanna, but if it's because of, if he has a assigned judge that's here, I don't know that it's appropriate for me.
But I really don't know anything
Yeah.
about it.
And Your Honor, it'll just take me 1 second, because it looks like, I just looked in BSO Picks, it looks like it's on a capias, so if it's a court-ordered capias, I don't know that there's anything.
Right. We'll talk to Nadine, review it over the break, and then if appropriate, we can discuss it for the afternoon. Okay, off.